name some of them. Today, today we have a nice experience with him. With consistent efforts and perseverance, he is now working as an associate in the firm Maestro Legal and meeting demands of the clients not only in India but expanded in abroad as well as. And he is a best speaker in the Nalsar PL Moot and the second best memorial Surana and Surana National Trial Advocacy Competition, best speaker of the finals issued by the Surana and the Surana and NLU IU Bhopal, winner Surana and Surana National Trial Advocacy Competition by Surana and Surana and NLIU Bhopal. Sir, welcome to you. Now over to you, Vaibhav Sai, sir.
Thank you, Dr. Dheeraj. Thank you, Uda ma'am, for having me here. It is absolute pleasure and commendable efforts that you are conducting such workshop or training in our institute. I think this is the first time we have come together for a moot court training.
Yeah, thank you, Vaibhav Sahiji, because I got this idea from you people only, because I could saw a excellent training and work, and one of your website I saw Legal Maestro for this purpose, and even I experienced that our students were in great difficulties while participating in moot court competitions, and even many of the faculty were not able to provide proper guidance and appropriate technicalities regarding memorials. And the whole idea behind this is you, and we are lucky that we got to hear you. Our participants are with you, and I'm sure they are going to be benefited with all your expertise. Welcome to you, sir.
Thank you so much. So I think you already had a session with Mr. Mishra yesterday, and we'll basically continue from where he left. So beginning with, just a second, I'll share my slides. We'll basically discuss about the significance of mooting in this workshop, and we'll take it ahead from the memorial submissions part. Is my screen visible to you, everyone?
No, sir.
Yes, now it's visible, sir.
Yes, sir.
Okay. Thank you so much. Now, see, when we talk about any moot court competition, what is a master of any moot court competition? Taken towards winning any moot court competition, as per me and as per many other people, those who have done mooting. So this is whatever I'm telling you today is basically out of my own experience. See, laws are nearly same. Every one or the other team will use the same laws, but facts are very different for all the teams. It is basically depending upon how you are interpreting those particular facts, and where we say that is the first towards winning. The way you understand your moot proposition is how you're gonna present it in front of judges. So what are the things which we keep in mind while reading the proposition is that you have to engulf the facts of the case, all the facts, and you don't begin like anything else. Firstly, sit down, read out the moot position, fair timeline of the events. We as advocates as well have been doing it. So whenever a case comes to us, what we do at the first instance is to prepare a timeline of the case. Unless and until we know the timeline of the case, how can we tell it to the judge? It's not possible. So what we do, we prepare a timeline including the dates and the events. And once that is done, now you stick with that time. You imbibe that timeline, you memorize that timeline, it should be there in your head. So apart from this, what are the other factors to remember? Remember the facts in line para by para. If a judge asks you a particular fact, it should not be that yes, it is present moot proposition. आपको जज को बताना है कि my lords, it is present on this page, this para number, this line number. You should understand everything. Tell you a story that once we were preparing for our moots, what we used to do is that we first put para numbers on all the paragraphs and then line numbers on all the lines, so that we remember that how we are going to take it ahead. And if suppose some question comes, then we can easily tell them that, see, we are referring to this paragraph number, this line number. And it's very impressive for the judge. It's very impressive how you present yourself to the judge. Then another important thing is, you should know the data, you should know the dates, you should know the measures, you should know everything. These are the basic things which you keep in mind for any moot court competition. I'll not come to the memorial part, I'll not come to the other parts, because I think that is already dealt with the other resource person. I'm just telling you that how you can make a significant change in your preparation by taking this particular point ahead. Suppose there is a criminal law moot. What is to be done? In that case, you don't assume that the moot proposition is the fact sheet. And why so? Because of a simple reason that the defense views are always different. The moot proposition will have the prosecution points of view. And what do you have to do? You have to present both the views. You have to present the views of a prosecutor, which is given in the moot proposition, and you have to present the views of the defense counsel as well. So you have to think like that. You have to think about what could be the reasoning of the defense. So, may I know which year's student I am referring to? Are we, the students are from third year, fourth year? Which year are we referring to?
Students, Advocate Vaibhav, are from first year to final year, mixed.
Okay. So suppose if you are going to take the plea of alibi, those who understand, those who know the basics of criminal law, those who have read the Evidence Act, suppose you want to go ahead with the plea of alibi. Now you have to be very clear that what plea of alibi is. And moot proposition will not tell you that you have to take the plea of alibi. So it is basically the team members, they sit together and decide that, see, this is what our course of action would be. Whether it is plea of alibi, whether it is general defenses, whatever it may be, you have to be very clear on it. Sometimes moot proposition, they are not very clear with the defense point of view, because this is something which you have to decide. This is something which you have to research upon, and this is how this is how it goes ahead. Now it's always the dispute or set facts in the proposition. जब proposition को पढ़ेंगे तो उसमें दो तरह के facts होते हैं. एक आपका disputed fact होता है, एक undisputed fact होता है. So there is no point of arguing on the undisputed fact. Both the parties are agreeing. Why do you have to waste your time on by arguing on that particular thing? Don't do. Leave the settled facts aside. Those are agreed facts. What we have to bother about is the disputed fact, the facts which are not agreed by the party, and those facts will only make a difference. जो agreed है उसको हम घुमाएंगे फिराएंगे, हमारी मेहनत बर्बाद होगी, ज्यादा नहीं होने वाला. But if we talk about a disputed fact, definitely you have to give your point of view in that. To tell out disputed facts and he representing the defense have this point of view. So this is how it goes ahead. Now, if the prosecution must have relevance to each of the argued facts in order for him to be admissible in the court of law. जो भी disputed fact होंगे, उसके लिए the prosecutor is the person responsible to prove that facts, or to prove the facts. Because if you understand the basic of criminal jurisprudence, is there any question? Somebody is trying to speak. Any questions?
It may be by mistake. We can move on. I think
So
somebody left.
This is how you have to perceive the facts, and perceiving is very important. Now, understanding the research methodology is also very important thing. What do you do first when you get a moot proposition? Where do you get the research from? So you get your research from the commentaries which are there in the library. People tend to avoid those commentaries, but don't have to avoid those commentaries, guys. Those are the best possible research points which are available, and you can easily get case laws and other details by the commentaries. Suppose you are reading about the Prevention of Money Laundering Act. In such cases, go and read out the landmark judgments which are available. Some acts are very short and there are 2-3 judgments which cover the entire act. So please keep that thing in mind. Please keep that thing in mind and read the particular landmark judgments. So if you are reading about the Prevention of Money Laundering Act, the Jayalalitha judgment is very famous, and it covers entirely the whole Money Laundering Act, because of simple reasons that the operative part of Money Laundering Act is from Section 2 to Section 7. And the Jayalalitha judgment covers all of them. Then there are certain portals which are available. I think it is available in your campus as well, like SCC Online, JStore. And for me, as a mooter, the most important research or resource which is available is Google. You get the answer of all the things on Google. It is just that you have to be very clear with what you are picking, and you have to verify it from various sources, because unless you verify things from other sources, you might be wrong at times. Be cautious regarding each case as to whether they have been overruled by any subsequent authority. Suppose you are arguing a very important matter और आप उस केस पे रिलाई कर रहे हैं जिसको सुप्रीम कोर्ट ने 2 साल पहले, 1 साल पहले, 6 महीने पहले ओवर रूल कर दिया है. What would be the relevancy? Even if you quote that particular judgment, तो उसकी relevancy कुछ नहीं होगी, because that particular point of view is overruled by the Supreme Court of India or by any other high. जो practical points जो ध्यान में रखने हैं आपको, those are firstly that suppose you are arguing before a 3-judge bench, तो उनको 2-judge bench का कोई judgment मत बताइए. That can only have it will not have a binding value on the bench. अगर आप 5-judge bench के सामने आर्ग्यू कर रहे हैं तो उनको 3-judge bench का आर्ग्यूमेंट मत बताइए, 3-judge bench का जजमेंट मत बताइए, because that will also not have any binding effect on that particular bench. Suppose you are arguing in one high court, don't tell them the judgment of other high court. Try and find some relevant judgment of the same high court. And if you are arguing in Supreme Court, then don't tell them the judgment of the high court, because these are not having any binding values. So what you have to keep in mind, firstly, that the judgments are not overruled, and secondly, that you are not referring to irrelevant judgments. अब these things come through time. जितना time आप research में invest करेंगे, जितना ही समय देंगे, उतना ज़्यादा ये चीजें निकल के आपके सामने आएंगी. And this is something which is only up to you. You have to do this. And research methodology should be such that nobody should be able to point out a question on your research. इतना stringent research होना चाहिए हमारा. As a competition, never take it as just an exercise. आप उस particular facts को, जब तक you'll not live that particular fact, you'll not be in a position to do very well in a competition. Why am I saying this? Because ये एक exercise नहीं है बस. It's not just simple exercise. You are getting prepared for the future. You will represent in various high courts and Supreme Court and the district courts. And we expect to know everything. We expect you to be prepared. So never take it as a competition. Be very thorough and be very prepared. Now, what are the other things which you keep in mind? Whenever you read the cases, जब भी आप कोई judgment पढ़ेंगे तो उसमें there is a viewpoint of the defendant. तो जब भी इनके व्यू पॉइंट्स पढ़ेंगे, I have seen students, because I am also judging various competitions, I have seen people, they refer to that particular argumentation. This is something which you have to avoid. क्योंकि किसी भी जजमेंट के दो ही पार्ट्स काम के होते हैं, एक आपका रेशियो और दूसरा ओबाइटर. So whatever you are referring to, you either refer to the ratio of the judgment or you refer to the obiter. अगर आप argumentation of the counsel को बीच में ले आते हैं, that will be of no use. And I'll tell you a story. I was arguing at the Amity 16th Amity National Moot Court competition, and there was a judge sitting in front of me in the quarterfinals. और जो प्रॉब्लम थी वो मनी लॉन्ड्रिंग के ऊपर थी. तो जज साहब ने, he asked me that which is the case law you are referring to here. I told him very boldly that it was my first moot, so by Supreme Court of India, and Supreme Court has laid down this particular thing. Though the case was not from the Supreme Court of India, but you know, at times we as students feel that the judge would not know and all the cases available in this country. तो हम बोल देते हैं कि सर ये यहाँ का केस है, नहीं पता है कि if the judge knows or not. He said, no counsel, it is not from the Supreme Court of India, it is the case by Karnataka High Court. I said, no my lord, it is by Supreme Court of India. He said Supreme Court of India has not, because he was the person arguing that case in the Supreme Court of India. तो उनको पता था कि अभी इस पे फाइनल ऑर्डर नहीं आया है. तो अगर आप ऐसे ब्लफ करेंगे जज के सामने, तो देयर आर चांसेस दैट पहले तो कंपटीशन से बाहर होंगे, दूसरी जो बेइज्जती होनी वो अलग होगी. So I don't know whether you have heard of this particular phrase in your law school or not, but we have heard many a times. Though refrain from doing such, not convince the judge, confuse the judge, but refrain from doing it. At times judges will not be confused because they have better experience than you. You are just a law student. Just keep this thing in mind. Another very important aspect is knowing the forum. Whatever moot court it may be, you have to know what the forum. Unless and until you know the forum, it becomes very difficult to know what are the laws governing that forum. अगर आपको ये लग रहा है अभी, because see I assume you to be law students from 1st to 5th year, and by virtue of being a law student I know that you'll not be well versed with all the laws available in this country. So if you think it is the constitution alone, then dear students, you are highly mistaken. Supreme Court is governed by the Supreme Court rules. High Court is governed by various High Court rules from various High Courts. District courts are governed by various other rules. And these are not those rules which are available in public domain. Unless and until you are highly engrossed with that particular forum, you would not know the rules governing that particular area. For example, clubbing of cases by the Supreme Court is present in very brief in the Constitution of India. But do you know the procedure of clubbing of the cases by the Supreme Court? You might not know. Why? Because it is the Supreme Court rules which tell us that, see, this is the procedure of clubbing of matters. And neither I expect you to know, because see, these are the things which you will come to know over the course of practice. So first thing is that whenever you begin with a proposition, whenever you begin with a moot court, know your forum. That is the very first thing which you should keep in mind. It is also important to be well versed with the provisions which allow you to appear before a particular forum. Because unless and until you know the procedure or the provision how you can be present in front of a particular forum, you know it becomes very difficult why the judge will listen to you. The people judging you in a moot court are experienced mooters, and they have faced much humiliation while their preparation, while they were mooting in their college days. And they tend to return back to you what they have got in their mooting days. तो इस पे बड़ा क्लियर रहिएगा कि कहीं पे आपको हॉट बेंचेस मिल सकती हैं, which means you will not be in a position bench. कहीं पे आपको कोल्ड बेंचेस मिल सकती हैं, which means that they will not ask any questions to you. So you have to be prepared for all these particular aspects. You have to be prepared for all or any questions, whether related or not related to the moot proposition. Only then you can expect that you can do something worth moving ahead. At times you are working on a problem which is basically going to some tribunal, some commission, some other judicial forum. Especially in the recent trend, what we have seen people making proposition regarding the competition law, because it is the most emerging law. And by virtue of that, you have to know the rules governing those particular forums as well. Unless you know it, it is very difficult to take it ahead. Another important aspects of international forums, whether it is the International Court of Justice, whether it is the International Criminal Court, whether it is the European Court of Human Rights, whether it is the American Court of Human Rights, you have to know that what are the rules governing that particular court, what are the provisions governing that particular court. Now coming to the most important aspect of today's session is how to succeed in the oral rounds. For succeeding in the oral rounds, I'm telling you out of my own experience that the most important thing to keep in mind is, do you people know what is Iraq? Students, do you know what is IRAC?
No, sir.
I think it was there in the yesterday's session also.
Yes, sir. Yes, sir.
Yeah. So IRAC is basically issue, rule, analysis and conclusion. जब भी आप अपीयर होंगे किसी कोर्ट के सामने, तो सबसे पहले अपने इंट्रोडक्शन के बाद उसको क्या बताएंगे? That my lords, this is the issue before this court. This is the question of law before this court. This is the problem. सबसे important तो वही है. Unless and until the court knows that what it has to adjudicate upon, how can we expect the court to adjudicate upon that particular issues? तो सबसे पहले आपको क्या बताना है? आपको issue बताना है. Then you have to tell the rule, that is the law which is being used in this particular issue, the law which is in effect and the law which governs this particular issue. तो आपको दूसरे नंबर पे क्या बताना है? You have to tell the rule, and then based on the issue, rules, you have to find the analysis. X is the reason for this, Y is the reason for this, therefore we are coming to this particular conclusion by this analogy. तो फिर आप एनालिसिस करके उसको कंक्लूड करते हैं. दिस इज हाउ एनी मूड कोर्ट इज गवर्न्ड. और यही तरीका होता है किसी भी मूड कोर्ट में आपको सक्सीड करने का. कीप इट वेरी सिंपल. जितना आप गोल गोल बातों को घुमाएंगे, जज विल गेट कंफ्यूज्ड एंड देयर वुड बी चांसेस दैट ही वुड नॉट अंडरस्टैंड थिंग्स. And since he would not understand things, there would be chances कि वो आपको कम मार्क्स दें, कम मार्क करें, कुछ भी पॉसिबल. Or adhere to court mannerism. What you have to do? You have to adhere to the court mannerism. कोर्ट मैनरिज्म क्या होता है? जब भी आप कोर्ट के सामने अपीयर होते हैं, you have to keep various things in mind. And what are those things? That you greet the bench accordingly. बहुत लोग की आदत होती है, they argue with pen in their hand. Don't do that. Judges will not like it. बहुत लोग की आदत होती है, they point finger and argue. Don't do that. And not only for moot courts, never do it in front of a real judge in the court of law. Judges will not like anybody to point fingers at them and argue. So adhere to all these issues. Be humble, be polite, stand upright. Don't lean on the podium which is available. Show the judge that you are energetic enough to defend your case. अगर आप ही कॉन्फिडेंट नहीं हैं, तो जज को आपके क्लाइंट पे कॉन्फिडेंस कैसे आएगा? Very basic thing to keep in mind. Be very confident. Be such confident that the judge should be bound to listen to you. जज को लगना चाहिए कि you are telling something very important. Believe me, you can never defend your client. It's very difficult. And refrain from any hand or body movements while arguing. One more important thing to be kept in mind are the compendiums. Now, what are compendiums? जब भी आप मेमोरियल बनाएंगे, कल शायद आपको कोई मेमोरियल दिखाया भी गया होगा, उस मेमोरियल में आपको पता चलेगा कि there are certain case laws which you are referring to, there are certain books which you are referring to, all at one place in the form of a book, and that book shall be referred as the compendium, and present that compendium to the judge. करेंगे, जज को पता चलेगा कि आप रिसर्च करके आए हैं, you know the law, you know the case law. इसलिए it is very important. Suppose अगर जज आपसे केस लॉ पूछ ले और आपने बता दिया, and he asks you to present it in front of the court, and you are not doing it, what will happen? The judge will think of it that you are making him fool and nothing else. So be ready with the case laws, be ready with the research material what you are referring to. It should be well marked, well flagged, and it should be, you should place stick so that it is easy for the judge to refer. आप जब plead करें तो बताइए जज को that your honors refer to flag number this of the compendium which has the judgment of X versus Y. You should know everything about the judgment. You should know the judgment. You should know the citation. You should know the judge's name. You should know everything in detail. Because if you don't know these things, then what is the point of research? I have faced judges who have asked me minute, tiny details about the case law, and you have to know it. It's very important. And this is the work of your compendium. And also you have to keep in mind that you do not disclose your college's identity anywhere. Because in case you are disclosing your college's identity, it becomes very difficult for the judge to like oversee it. There are chances that I would be judging you people in some moot court competition, and suppose disclose your college's identity that I am from this particular university, I'll definitely have a soft corner for you all because I have trained you guys to argue. So avoid doing these things. And at times I may feel that you're doing it willfully because you know Mr. Weber Shahi, he has trained you. I'll tell him the college name. He will get to know me and he will mark me high. There may be chances. So avoid doing it. It can backfire at times. And at the end, a very important thing is the prayer. Be specific on your request for relief. इधर उधर की बात हम नहीं करेंगे. जो कोर्ट से मांगना है as relief हम उसी की बस बात करेंगे. And the exact damages that you see, don't leave it to the court. Your honors, give it accordingly. Ask it specifically that your honors, I have incurred damages of such and such, and in relief I need such and such. In case you are defendant respondent, then simply ask for the dismissal of the suit. Mention the exact punishment what you need. So the prayer has to be specific. The prayer can not be imaginary. it has to be specific. And you have to keep these things in mind while arguing any case in front of the judge. So with this, my slides have come to end. I have told you ample information on how you have to present in front of the judge. It's everything which should come from, like, it should come from within your heart, whatever you argue before the court. Unless and until you do that, believe me, no judge would listen to you. The most important thing I told you today is that अगर आज आप 2 महीने प्रैक्टिस करके एक केस नहीं जीत पा रहे हैं, कल को जब आप कोर्ट में जाएंगे और आपको हर दिन अपीयर होना पड़ेगा अलग अलग केसेस में, टेल मी हाउ वुड यू डू दैट? It will become very tough for you. You should understand, unless and until you understand the pain, the agony of the complainant, of the victim, how would you be able to make it understand to the judge? फेस से गुजर रहा है तो आप जज को कैसे बताएंगे? You should know and understand all these basic aspects. With this, I'm concluding the session and opening the floor for question and answers. If there are any questions.
Doubts?
No, ma'am.
Okay. Thank you, Advocate Weber, sir. I hope you have done a great job because I do not see any doubts from the student side.
This mean both the things, ma'am. Either I have done a great job or either the job was not good, so that there are no questions.
No, I'm
at
sure
all.
definitely you have done a great job because everything you made very clearly, and each and every slides contain all the specific and relevant informations that students need to know.
I think somebody is raising hand, ma'am. If Saloni Prakash, if you have any questions.
Yeah, but Vaibhav sir, if I have any doubt, may I?
Yes, ma'am.
Yes. So my point is, while preparing for a civil moot problem or criminal moot problem, what sort of difference the mooters need to make out while preparing memorial? Matter of arguing on the issues or any specific points, they will go specifically according to the law and the procedure. But is there any point of difference while preparing memorials or addressing the court?
Yes. So thank you for the question, ma'am. Very important point. Now, there are two basic differences which they should always keep in mind while both preparing for a civil case and criminal case and arguing a civil case and criminal case. In civil cases, they usually get both the side of the story in the moot proposition itself. There are very less chances for imagination. अगर कोई डिस्प्यूट है किसी रिकवरी को लेके, सपोज 5 करोड़ 10 करोड़ की कोई रिकवरी है, तो ए और बी दोनों से रिलेटेड फैक्ट्स वुड बी देयर इन द मूट प्रोपोजिशन. बट अगर कोई मर्डर हुआ है तो देयर आर चांसेस दैट ईदर द फैक्ट्स आर नॉट गिवन फ्रॉम द साइड ऑफ द डिफेंस या there are chances that they have not analyzed the facts in that particular way. अब एक बड़ा छोटा सा एग्जांपल है मैम, दैट फुटप्रिंट्स, जब आप कभी भी कोई अगर क्राइम सीन होता है या क्राइम सीन इन्वेस्टिगेशन, अगर कभी किसी को मौका मिला हो क्राइम सीन इन्वेस्टिगेशन देखने का, फुटप्रिंट्स की बहुत बड़ी वैल्यू होती है मैम। और ये किसी लॉ स्कूल में नहीं पढ़ाया जाएगा इनको कि फुटप्रिंट्स की क्या वैल्यू होती है। ना ही कोई किताब अवेलेबल है इस कंट्री में जिसमें फुटप्रिंट्स के वैल्यू को समझाया गया, अपार्ट फ्रॉम वुडरॉफ एंड आमिर अली, जिसमें एक डेडिकेटेड चैप्टर है फुटप्रिंट्स के वैल्यू पे। तो अनलेस एंड अनटिल दे नो कि क्या वैल्यू है उस पर्टिकुलर चीज की, it would not be possible for them to take into consideration that particular issue. Specifically, आप अगर जो भी क्रिमिनल लॉ के फैकल्टीज यहाँ पे होंगे और पढ़ाते होंगे, they know the thing ma'am, that सिमिलर पनिशमेंट डिमांड नहीं करता है। अगर किसी का मर्डर एक बार चाकू मारने से हुआ है तो शायद उतनी पनिशमेंट ना मिले जितनी 50 बार चाकू मारने वाले को मिले। अगर किसी का मर्डर हो गया, पैर में गोली मारने से एक्सेसिव ब्लड लॉस हुआ और मर्डर हो गया, उसको शायद उतनी पनिशमेंट ना मिले जितनी उस बंदे को मिले जिसने किसी के सर में गोली मारी है, क्योंकि इन सारी चीजों पे डिस्कशन होता है कोर्ट में। इन सारी चीजों से हम मोटिव, इंटेंशन, एक्टस रियस, मेंस रिया सबको अलग करके दिखाते हैं जजेस को। तो क्रिमिनल लॉ में आपको बहुत विजिलेंट होना पड़ेगा रिसर्च के टाइम पे। क्रिमिनल लॉ में दे हैव टू अंडरस्टैंड द बेसिक्स। अब जब आर्ग्यूमेंट की बात आती है तो क्रिमिनल लॉ में दे हैव टू बी फेरोशियस, दे हैव टू, इट शुड लुक लाइक दैट दे आर फाइटिंग। अगर प्रोसिक्यूटर एकदम विनम्रता से जाके बोले कि माय लॉर्ड्स, मिस्टर एक्स एंड मिस्टर वाई, दे हैव कमिटेड द ऑफेंस ऑफ रेप और ऑफेंस ऑफ मर्डर and hence they should be punished, will the judge ever believe to it? Not at all. You have to show the judge the pain and the agony through which the victims are going through. You have to show the judge how the offense was committed. Same goes for the accused. Accused के जो एडवोकेट होंगे, they have to show it very well कि my lords ये सिचुएशन है, सोल ब्रेड अर्नर ऑफ द फैमिली है, कोई पास क्रिमिनल रिकॉर्ड नहीं है, and then you will be at times able to convince the judge. Apart from it, find loopholes in the theory of the prosecutor. Why was the FIR not registered on? Always question these facts. Why was the medical of the accused not conducted soon after any offense against a woman happened? Why was the medical of the victim not conducted soon after the offense was reported or happened? क्योंकि ये सारे these are the holes in the theory of the prosecutor, और बहुत विजिलेंटली आपको एक छोटे छोटे चीजों को क्वेश्चन करना पड़ेगा, because if you forget to question these things, believe me, क्रिमिनल में तो कोई ऑप्शन नहीं है आपके पास। सिविल में यू डील विद मॉनेटरी लॉस, यू डील विद मॉनेटरी डैमेज। क्रिमिनल में लाइफ ऑफ अ पर्सन इज एट स्टेक. आपके हाथ में किसी की जिंदगी. So be very clear, be very vigilant on this. And this is the basic difference between a civil moot court and a criminal moot court. Any other questions?
Yeah, Vaibhav, one thing more our participants would like to know
Yes, ma'am.
on because I am receiving few WhatsApp from student side.
Okay.
The doubt is in some criminal mooting problems, the mooters they have only some facts, some point of law to put forward to research about, like report, actual report, FIR, investigation report, IO report, and some other procedural loops and lacunas which advocate uh, can make out for the interest of the client and in support of his or her uh, claim or assertions. The mooters doesn't get that. Then how to make their point strong? Because what they get is the only problem. Anything they will put forward that may be treated as imaginary, assumptions based or something. They do not contradict that IO report में ये missing है या उन्होंने due procedure follow नहीं किया. जनरली बिफोर द कोर्ट हम ये प्लीड करते हैं कि आईओ ने ये प्रोसीजर मिस कर दिया और वो बहुत इंपॉर्टेंट पार्ट है. इस तरीके से ना कहीं जो क्रिमिनल लॉयर है वो अपने क्लाइंट के लिए वो कहीं ना कहीं वो वहां से पॉइंट्स ढूंढ लेता है आर्ग्यूमेंट का, डिफेंड करने का या उसको आगे स्ट्रोंगली कन्विंस करने का कोर्ट. लेकिन एक मूटर के सामने ये बहुत बड़ी प्रॉब्लम है कि वो इस तरह के लूप्स अगर वो इमेजिनरी हाइपोथेटिकली अगर प्लीड करे तो उसको सपोर्ट कैसे करे वो.
मैम इसका बड़ा सिंपल सा आंसर है. जब भी हम क्रिमिनल लॉ मूट करते हैं, मैटर या तो हाई कोर्ट जाता है या तो सुप्रीम कोर्ट जाता है. जब मैटर हाई कोर्ट या सुप्रीम कोर्ट जाता है तो हम वहां पे बहस फैक्ट्स पे कभी नहीं करते हैं. ये जो भी चीजें हम बात कर रहे हैं, चाहे वो आईओ रिपोर्ट की बात हो, चाहे चार्जशीट की बात हो, चाहे फॉरेंसिक की बात हो, ये सारे मैटर ऑफ फैक्ट है. और सुप्रीम कोर्ट में अगर आप मैटर ऑफ फैक्ट पे आर्ग्यू भी करेंगे तो दैट वुड नॉट बी हेल्पफुल एट ऑल. हमें बात किस चीज पे करनी है? हमें बात करनी है लॉ पे. स्पेसिफिकली व्हेन वी टॉक अबाउट द सुप्रीम कोर्ट, we have to tell the lacunas, we have to tell that what is the issue with the law and why the accused should be set free. Because Supreme Court will never entertain the facts which we are telling them. Or this is a established procedure also कि आप fact पे बहस नहीं करेंगे सुप्रीम कोर्ट के सामने, बिकॉज इट इज द कोर्ट ऑफ लॉ. इसीलिए मतलब दिस इज अ मेजर रीजन व्हाई द मूट प्रॉब्लम्स व्हिच वी हैव does not contain all the basic details like all the reports by the IO, by the forensic, by the other investigators. जनरली नहीं होती है क्योंकि आप इधर बात करते हैं वहां पे किसी पर्टिकुलर लॉ को अपहोल्ड करने की, किसी पर्टिकुलर लॉ के कॉन्स्टिट्यूशनल वैलिडिटी की, किसी प्रोसीजरल लैक्यूना की, तो वो मूट प्रोपोजिशन में दे हैव प्रोवाइडेड. दिस इज अ मेजर रीजन व्हाई दीस थिंग्स आर मिसिंग. हालांकि सम मूट प्रॉब्लम्स आर वेरी वेरी लूजली मेड एंड आप यू विल फाइंड दैट in those moot problems it would not be like very clear that what you have to argue, what was the stand of the prosecutor, what was the stand of the defense. It becomes difficult, but that is how we deal with the issues, and everything comes with experience. In my entire mooting career I have done around 12-13 moots, so whatever I have learned is out of my experience. And believe me, for all the students, if somebody is telling you that moods are not important, go to the High Court, go to the Supreme Court and listen to the arguments. It's nearly similar to what you do in a moot court competition. I'm not telling about the district court because there are a lot of procedures which are present in the district court. But for high courts and supreme courts, I can say yes, that it is very similar to what you are doing in a competition. And hence, it is for everybody, all the students, they should definitely do 1 or 2 moots in their entire law school career. Any other questions? Somebody is raising hand. Kajal.
Kajal?
Sir, two question asked chat box, sir, in the Chinky
Yes,
BBA and the Colony Prakash, sir,
Yes.
in the chat box, sir.
What
They
if
have-
we are in doubt or confused about whether it's correct or not? Then how should we answer that question? Whether, sir, what if we are in doubt or confused about answering any question? See, at first, if it is related to any law, you have to be very clear with the law. If you don't know the law, don't make the judge fool, because he knows the law. अगर facts पे हैं तो bring it. It's very advisable. कोई question judge अगर पूछ रहा है तो उसको answer fact sheet के through दिया जाए, क्योंकि वो fact sheet जो होती है, that is the master of any moot court competition. Answer to all the questions are generally present in the fact sheet, specifically when it is not related to any particular law. तो उस पे आपको fact sheet पे थोड़ा ज़्यादा ध्यान देना पड़ेगा, and it's better to take that route. Saloni has asked, I have a question. What if I am representing a case which is related to a commercial suit, and there, as an advocate, I am presenting a judgment which is important to go inside of the case in front of the judge, and if the judge is not aware about the judgment in that case, so should I leave the judgment which I quoted? No, you tell the judgment, you refer the judgment, you show the judgment. आपको शायद जजमेंट पढ़ने में 1 घंटे 2 घंटे लगते होंगे, बट एडवोकेट्स को उतना टाइम नहीं लगता है, बिकॉज दे नो व्हाट टू रीड. They don't have to read the full judgment. You just show them the operative part. They will understand the issue. They'll head note से उनको पता चल जाएगा issue क्या है और solution क्या है. तो they'll not take time. आप judgment जो refer कर रहे हैं, अगर आप sure हैं उसके लिए, then do refer to that judgment. I think there are no other questions. Yes, ma'am.
I'm sure you are not getting late, Vaibhav.
Not an issue, ma'am. I'm
Okay,
still
there is
available.
one doubt from our faculty, young faculty. She is a member of Moot Court Committee, and she want to know whether a moot problem comes or is assigned to frame by her. Can she choose a pending case? Is it wise to go for a decided case or a pending case to
So,
frame?
see, when we talk about moot propositions,
Yes.
recently I drafted the moot proposition for Amity Jaipur, and we are not focusing on any pending case, or we are neither focusing on any decided case.
Okay.
We have discussed about something called as metaverse के अंदर अगर कोई crime होता है तो उसको कैसे tackle. Laws are not present. So it totally depends on the mindset of a particular person कि वो क्या करना चाह रहे हैं. Decided cases में it becomes very easy, क्योंकि बच्चों को पता होता है कि हमें argumentation किस पे based बनाना है. जो पेंडिंग केसेस होते हैं उसमें रिसर्च थोड़ी ज़्यादा लगती है, और कुछ केसेस होते हैं जो फ्यूचरिस्टिक केसेस होते हैं कि फ्यूचर में ऐसा होगा तो कैसा होगा. तो वो जो पर्टिकुलर केसेस होते हैं वो बेसिकली उस पे मूट प्रॉब्लम्स इसलिए बनती हैं कि हम एक ज्यूरिस्प्रूडेंस डेवलप कर पाएं उसके अराउंड, एक हम कुछ अलग डिस्कशन कर पाएं उसके अराउंड, सो दैट इफ सर्टेन सिचुएशन अराइजेस इन फ्यूचर वी आर प्रिपेयर्ड फॉर इट. तो ये टोटली मूट कोर्ट का जो भी डिजाइन कर रहा है मूट प्रोपोजिशन, इट इज टोटली हिज विश हाउ ही कैन टेक इट अहेड. इट इज एडवाइजेबल टू गो फॉर ईदर फ्यूचरिस्टिक और पेंडिंग केसेस, क्योंकि डिसाइडेड केसेस में यू नो द लॉ, यू नो द फैक्ट्स, और आप चीज़ों को कर पाएंगे. इट इज़ रैदर एडवाइजेबल कि आप 2-3 चीज़ मिंगल करके बनाएं, ताकि बच्चों का भी कॉन्फिडेंस लो ना हो कि कुछ मिल ही नहीं रहा है रिसर्च करने पे. तो अगर आप पेंडिंग का एक इशू डाल दिया और कुछ किसी और का भी एक इशू डाल दिया और फ्यूचर का भी कुछ एक इशू डाल दिया, तो वो थोड़ा सा एक एमलगमेशन अच्छा बन सकता है.
ओके, कुछ मूट प्रपोजिशंस में ना इश्यूज सेपरेट मेड आउट रहते हैं. कुछ प्रपोजिशंस में इट इज लेफ्ट टू द टीम एंड द मूटर्स कि वो मेक आउट करें. So, what is advisable?
तो
We should
मैम
make
सी
out and fix the issues, and we should keep it open.
टॉक अबाउट सिविल केसेस पर्टिकुलरली, उसकी इश्यूज फ्रेमिंग कोर्ट के अंदर होती है. तो एडवाइजेबल तो यही होता है कि आप व्हेन यू आर मेकिंग द मूड प्रोपोजिशन सो वेल कि उसको पढ़ने के बाद ये समझ में आ जाए कि इशू क्या है, तो आप ओपन एंडेड छोड़ दीजिए. लेट द स्टूडेंट्स मेक द इश्यूज, बिकॉज दैट विल ट्रेन देम हाउ टू मेक इश्यूज एज वेल. दैट इज ऑल्सो एन आर्ट. That is all something which they have to develop over the course of time. But अगर बड़ा confusing सा मूड proposition बना है, लॉ नहीं अवेलेबल है, फैक्ट्स नहीं क्लियर हैं, तो उसमें एडवाइजेबल ये होता है कि आप ओपन एंडेड छोड़ के बच्चों का टाइम वेस्ट करने की बजाय आप उसको क्लोजली नेट बना के यू lay down the issues and leave it like that. So that is something which could be done in such cases. There are some questions in the chat box as well. If a moot problem having civil and criminal problem, how can we proceed? There may be, see, civil and criminal दोनों साथ में तो नहीं होता है generally. There are chances कि substantive and procedural हो सकता है, कि आपका moot problem में substantive भी और procedure भी हो. Civil and criminal तो दोनों, तो ये पॉसिबल नहीं है. सर, आई हैव अ क्वेश्चन. इफ एज अ डिफेंडेंट लॉयर इन सिविल सूट रिगार्डिंग टाइटल डिस्प्यूट, हाउ टू स्टैंड ग्राउंड ऑन द सेम? हाँ, देयर आर केसेस, और ये रियलिस्टिक भी होता है कि अगर पिछला वकील कुछ ब्लंडर कर दिया है तो आप उसको कैसे संभालें. तो ऑब्वियसली प्रोसीजर्स पे ही आपको रिलाई करना पड़ेगा. देयर आर नो अदर थिंग्स विच आर अवेलेबल, बिकॉज यू कैन नॉट गो एंड आर्ग्यू कि पिछले वकील ब्लंडर कर दिया माय लॉर्ड्स एंड अब हम उस ब्लंडर को सुधारेंगे नहीं. जुडिशरी इज नॉट दैट फ्री, और ये तो क्लाइंट को डिसाइड करना होता है किसको वकील रखना है, किसको नहीं रखना है. तो क्लाइंट ने डिसाइड किया और तभी वकील यहाँ पे अवेलेबल था. वकील ने जो गलतियाँ की हैं उसको आप करेक्ट करना तो बड़ा मुश्किल हो जाता है. जो प्रोसीजर है उसके हिसाब से आप थोड़े बहुत उसको ट्वीक्स कर सकते हैं.
On a substantial fact, जो कोई नया इमरजेंस है, फैक्ट्स का नया रेवलेशंस है, या कोई प्रोसीजरल में कुछ नया है, ओनली ऑन दोज न्यू पॉइंट्स हम बिफोर द कोर्ट आर्ग्यू कर सकते हैं इन अपील इन ए क्रिमिनल केस और इधर इट इज सिविल केस. तो फ्रेश कोई इशू वहां पे ऑन पॉइंट ऑफ फैक्ट्स नहीं प्लीड होता.
नहीं,
व्हाट
on
आई
point of fact,
अंडरस्टैंड,
they will not listen also,
they will
क्योंकि
not.
fact settle हो
This is
जाता है.
established.
हाँ,
This is
fact settle.
already established. Yes.
एक क्वेश्चन है कि हाउ कैन वी नो दैट द जजमेंट इज ओवर रूल्ड. अगर एससीसी ऑनलाइन आपके पास है तो उसमें तो इजीली पता चल जाता है कि जजमेंट ओवर रूल्ड है कि नहीं. आप अगर एससीसी ऑनलाइन यूज करते हैं तो उसमें नीचे दिया होता है इट इज ओवर रूल्ड और नॉट.
Yes.
ऐसे पता करने के लिए तो इट विल टेक अ लॉट ऑफ टाइम एंड एनर्जी टू अंडरस्टैंड वेदर इट इज ओवर रूल्ड और नॉट. बट हाँ, अगर लेटेस्ट जजमेंट है, 2 महीने पहले की जजमेंट है और किसी पुराने जजमेंट को ओवर रूल कर रही है, तो डेफिनेटली दैट इज द लेटेस्ट जजमेंट अवेलेबल.
There is one more participants, Bhavna.
Yes, ma'am. Sir, I have a question. If we make the issues ourselves, then for both the sides, issue should be same and or can be different. Different हो सकते हैं issue. मतलब see, I have been experimenting in my whole mooting career. हमने different भी करके देखा है, same भी करके देखा है. क्या है और why is this issue even present? Totally आपके हाथ में है. अगर आपको confidence है कि आप उस चीज़ को defend कर सकते हैं, आपके पास ample law points हैं उस चीज़ को defend करने के लिए. So I don't see any harm why you should not make it different.
This is possible only when open-ended mooting
Yes,
proposition
only when
is
issues are not
available,
present.
is
Yes.
offered. Otherwise,
कुछ moot
mooters don't
propositions
have a
ऐसे
big
भी होते
choice
हैं
to
मैम,
make a difference and to deviate from the given.
कुछ propositions ऐसे भी होते हैं मैम जिसमें 4 issues दे के ये बोलता है कि आप एक issue कोई अपना भी बना के लाइए. तो उसमें भी आप ऐसा कर सकते हैं. The issues could be different. It is not necessary that the issue from both the sides should be same. Because आप एक बार किसी और के सामने अपीयर होंगे, किसी और राउंड में अपीयर होंगे और दूसरी बार किसी और राउंड में अपीयर होंगे. हालांकि कायदे से अगर कोर्ट ऑफ लॉ की बात करें तो इश्यूज तो म्यूचुअली डिसाइड होता है पार्टीज के बीच में और फिर उस पे आप कोर्ट एडजुडिकेट करता है.
Okay, मैं participant से पूछना चाहूंगी कि how many of you who are present in this meeting have ever participated in moot court competitions previously? You can leave in the chat box. We could get the idea. Are you completely raw, new to this concept of moot competitions, or have some kind of experience? Okay, Ritu, is this your question? In moot court, we should prepare our moot court file according to High Court rules. Obviously, Vaibhavji, will this make any difference while preparing the memorial when they are filing before the High Court or going to the Supreme Court?
जनरली नॉट. हाई कोर्ट और सुप्रीम कोर्ट में तो बहुत ज़्यादा डिफरेंस नहीं आता है. बट सपोज दे आर गोइंग फॉर डिस्ट्रिक्ट कोर्ट और हाई कोर्ट, उसमें डिफरेंस आएगा बिकॉज डिस्ट्रिक्ट कोर्ट में दे हैव टू फोकस ऑन द फैक्ट्स, दे हैव टू डिनाई, दे हैव टू एडमिट द फैक्ट्स. और हाई कोर्ट और सुप्रीम कोर्ट में दे हैव टू फोकस ऑन द लॉ. द मोर जजमेंट्स देयर इन, द मोर jurisprudence देयर इन, यू हैव टू फोकस ऑन दैट. तो ये डिफरेंस तो रहेगा ही.
Okay, what could I see that majority of the students are completely new to the idea of the moot court, but I would share कि बार काउंसिल ऑफ इंडिया ने कुछ सालों पहले, इट्स नॉट दैट मच न्यू कि अभी किया है, लेकिन बार काउंसिल ऑफ इंडिया ने एटलीस्ट 5 मूट पार्टिसिपेशंस मैंडेटरी आप लोगों के लिए किए हैं, एंड यू शुड स्टार्ट पार्टिसिपेटिंग फर्स्ट ईयर ऑनवर्ड. You shouldn't wait कि final year में आप आए when you are all aware about evidence, procedural aspects and substantive law, major and minor everything, and then you would be able to participate. Start taking chance, start participating from the first year onward. Obviously we are there, and I am thankful that Vaibhav and his partner yesterday they contributed in our endeavor, in our efforts in such a nice way. It's really overwhelming and motivating us to see that students are giving their responses, that they are feeling benefited and reached, and the crowd and the participation clearly reflects this, that how much they enjoyed and how much they needed all this. Thank you, Advocate Vaibhavji, and I hope you would not deny if we call you next time also.
Definitely not, ma'am. I would be available for any future assignments.
Our university is not very far away from Delhi. We are in vicinity of Sonipat, and if it time for you, please come to us in offline mode and spare few more sessions for our students.
Definitely, ma'am. Definitely.
Yeah, thank you so much.
Thank you so much.
Over to you, Dheeraj.
Thank you, ma'am. Thank you, sir. Very broad knowledge in the depth level. And he also told about the first step towards the winning and prepare the timeline. And few things should be remembered to the student. Understanding of the research methodology, read the commentaries, each and every of law that will be used in the arguments. And sir has given a very good in a punchline, research smarter, not harder. Important things is knowing the forms, national form, international form, and how to succeed in the alls. All the things and his experience give a nice understanding to all the students. We are very thankful to you, sir. Thank you, sir.
Thank you so much. Thank you. Thank you, ma'am.
Thank you, Vaibhav. Participants, I don't know all the participants are from BPS University or outsiders also, because the registration were huge. Uh, it touched almost 450, but I could see less number in the meeting. So all those who could not join this session, they can watch the videos, they can watch the recording or access through the YouTube channel, YouTube link. But in the upcoming session and in the valedictory section, I want to see the full strength. So stay connected, or those who will take leave for a short break, they please join again in time without making the resource person wait. So it's a direction, it's a request, and obviously this is for your benefit only. So all those who are from the BPS institution or outsiders, please make it in the meeting in time. Thank you. Share in your respective groups. Okay, Dheeraj. Thank you so much. Thank you,
Okay,
Dr.
ma'am.
Anu. Next
Dear
session is Dr. Sandhya Royal is the moderator, and resource person is Sohan Singh. We are going to see all the faculty members, all organizing committee, along with the participants
yes, ma'am.
by that time.
डियर पार्टिसिपेंट्स अभी जो नेक्स्ट सेशन स्टार्ट होगा वो 1:30 पे स्टार्ट होगा, तो आप सभी को बिफोर 10 मिनट्स यू हैव टू ज्वाइन द सेशन.
Thank you, sir.
Thank you, ma'am. Thank you.
Thank you, sir.
Hello, sir. Good afternoon. The drawing. Am I audible?
Yes, ma'am.
Yes. Okay. Okay. Uh, Good afternoon, Dr. Sohan, sir.
Good afternoon, Madam Ji.
I just want your permission for wait 3 or 5 minutes so that our
Yes.
participants may join us, right?
कोई दिक्कत कोई इशू नहीं है.
Okay,
What are
thank
the-
you, thank you, thank you. Good afternoon, ma'am.
Good afternoon, Sandhya. Sandhya, please background. Is this rightly set?
Ma'am, your voice is not so clear.
I'm saying, please check my background. Is this rightly visible?
Ma'am, it is visible but little blurred. Little blurred.
Uh, whether
I
it
can
is
see department of. I
depart-
can see. I can read department of. I
I hope
can.
it is not reverse. It is not
No,
mirror
no,
image.
it is
Fine,
clear.
fine, fine.
Otherwise,
Thank you.
but ma'am, it is not that every word is not readable.
Everybody.
Every word, like the. I think national moot court is not readable. Otherwise, it's completely fine, ma'am.
Okay, thank you so much.
It is fine.
Our resource person had joined.
Ma'am, he has joined us. Right.
Okay, we can start. Just a wait of 2-3 minutes with the permission of. Hello,
Hello,
yes,
ma'am.
sir.
Good
Very good afternoon, Sohan sir. Very good afternoon. It's nice to see you here, sir.
Same here, ma'am.
Thank you. Dear participants, please drop a message to join hurriedly so that we can start in time. Share in your contacts to join fast. Dr. Sandhya, I think we should start without making any wait to our resource person.
Okay, ma'am. Sure.
Yes.
With Dr. Rajesh Hutta and the director of the event and our resource person of today's technical session 4, Dr. Sohan Singh. it is a privilege and proud for me to introduce our resource person of the session, Dr. Sohan Singh. He is presently working as an district attorney of Haryana, posted at Panchkula, Haryana. And the sir has his PhD from Punjab University with the topic of judicial legislation in India and critical study. He has, after his PhD, joined Punjab University as a guest faculty as an assistant professor. In the year 2014, he has joined as an additional district attorney at Chandigarh administration, Chandigarh. In the year 2017 only, he joined as a district attorney of Haryana, and right now he's posted at Panchkula. So this is about the professional background of our resource person. But I can say that Sir has a full bag of knowledge and information to enlighten our participant on that issue of the criminal proceedings and drafting. Reason he has a rich experience, and somewhere the today's session is going to be focused by our resource person on the topic of investigation and the FIR, and including the criminal proceedings and drafting. So, sir, I, Dr. Sandhya Rohan, on behalf of the whole Department of Law and the organizing team of our National Moot Training Competition Skills Committee, I welcome you and giving this opportunity to our participant that they get enlightened themselves through your kind words. So thank you so much, sir, and over to you, please.
Thank you. Thanks a lot, ma'am. Today's topic is investigation related to criminal crimes. So first of all, the question raised, what is crime? Crime मेरी आवाज आ रही है आप लोगों को?
Yes, sir, you are audible. You are audible.
क्राइम एक ऐसी चीज है, यानी कि कोई भी लॉ में आपको रिस्ट्रिक्ट किया गया है कि ये काम नहीं करने हैं, अगर उसके विरुद्ध जाके कोई काम करता है तो उसको क्राइम कहा जाता है। कोई भी लॉ का ब्रीच करे। सबसे पहले कॉग्निजेबल एंड नॉन कॉग्निजेबल ऑफेंसेस। तो कॉग्निजेबल ऑफेंसेस हैं, उसमें अगर कोई एक रिपोर्ट आती है कि ये कॉग्निजेबल ऑफेंस रजिस्टर्ड हुआ है, तो उसको ड्यूटी है इन्वेस्टिगेशन एजेंसी पुलिस की मेनली कि उसी वक्त वो FIR रजिस्टर्ड करे विदाउट गोइंग इनटू द मेरिट ऑफ द केस, whether it is a false or fabricated. It's a duty of the investigating agency to register the FIR and proceeding further. During the course of investigation, if investigating agency deemed fit that this case is not going to be concluded as on the merit of the conviction, in that case, the police can file a cancellation report accordingly. But police has no other option to register a case in case of cognizable offences. In Supreme Court in 2013, Lalita Kumari versus State of UP, a constitutional bench judgment in which Supreme Court directed to the all state home secretary that any cognizable offence reported in the police station, generally it seems the police has not lost the FIR, but to delay the practice and to settle the matter out of the police station. This is not a good practice. It's a duty of the state agencies to register an FIR and proceeding accordingly as per the procedure of criminal procedure courts. Now question arises कि जब FIR हो गई, किन केसेस में हो गई और किस कंप्लेंट पे अगर कोई FIR होगी तो कंप्लेनेंट कौन होगा? पहला क्वेश्चन ये है। एक विक्टिम है, एक व्यक्ति ए है, उसका मर्डर हो गया, अब वो तो कंप्लेनेंट जनरली हो ही नहीं सकता। एक बंदे ने थाने में फोन किया कि फलां रोड पर एक लाश पड़ी है और 100 नंबर पे फोन करके डायल करके वो चला गया। इस पे डिस्प्यूट ये हुआ कि कई हाई कोर्ट और सुप्रीम कोर्ट की वेरियस जजमेंट्स ये कहती हैं कि कंप्लेनेंट वो फर्स्ट जो रिपोर्ट पुलिस को फोन आया 100 नंबर पे वो FIR है या लेटर ऑन पुलिस वहां पहुंची और फिर किसी और के स्टेटमेंट को रिकॉर्ड करके FIR लॉन्च की कि वो FIR है। तो सुप्रीम कोर्ट ने सेटल किया कि कोई भी ऐसी स्टेटमेंट जिससे ऑफेंस की कॉग्निजिबिलिटी का पता चलता है तो वो एफआईआर है। इन केस उस व्यक्ति ने अपनी स्टेटमेंट में पुलिस को सिर्फ इतना बताया कि एक व्यक्ति वहां पे एक अवस्था में रोड पे पड़ा है साइड में, तो वो एफआईआर नहीं हो सकती। अगर उस व्यक्ति ने पुलिस को टेलीफोन करके ये बताया है कि एक व्यक्ति की लाश उस स्पॉट पे पड़ी है, तो उस स्टेटमेंट को पुलिस अपनी डायरी में रजिस्टर करके एफआईआर करके जा सकती है अननोन के हिसाब से। लेटर ऑन पुलिस इन्वेस्टिगेशन करेगी, इंक्वायरी करेगी, और उसका उस विक्टिम का परिवार वाला कोई भी उसका रिलेटिव ये वो जो भी कंप्लेंट देगा वो 161 के स्टेटमेंट करके उसको भी पुलिस कंप्लेनेंट रख सकती है। ये प्रपोजिशन बिल्कुल, इस पे काफी डिस्प्यूट रहा, फिर वेरियस करके सुप्रीम कोर्ट ने इसको सेटल डाउन किया कि जो कॉग्निजेबल ऑफेंस है उसमें अगर जो भी कोई कंप्लेंट आई है, अगर उसमें कॉग्निजेबल ऑफेंस के इंग्रेडिएंट्स आ रहे हैं तो उस बेसिस पे एफआईआर की जा सकती है। एफआईआर के बाद पुलिस जनरली इन्वेस्टिगेट करेगी या फिर जो सस्पेक्ट होगा उसको अरेस्ट करेगी। तो उसमें पुलिस की क्या पावर है? सेक्शन 41 बताता है अरेस्ट ऑफ द एक्यूज्ड विदाउट वारंट। Generally, in cognizable offences, police can arrest the accused / suspect on the incognizable offences. If the offence is non-cognizable, then in that case, if police want to arrest the accused, then before arresting the accused, police has to take order from the magistrate or ilaka magistrate before going to arrest the accused. Power of police officer to investigate only cognizable offences. There is two kind of offences, cognizable and non-cognizable offences. Cognizable offences are the offences which have the punishment over 2 years or more. Non-bailable offences, generally cognizable offences are non-bailable except 2-3 offences which are bailable. Police can complete the investigation even without arresting the accused. It is not mandatory for the police to arrest the accused. Generally, in 420 forgery cases, cheating and forgery cases, it's a power of the police either to arrest the accused and interrogate him. If police is not want to arrest and interrogate the accused, police can file a charge sheet against those accused without arresting him before the honorable court. In case of matter of investigation, magistrate is not going to direct the investigation agency to investigate the case in a proper way. Only magistrate can supervise the investigation in some cases. If the honorable magistrate deems fit that the police is not going to do their duty as per the procedure of criminal civil procedure, in that cases, police magistrate can only supervise those investigations, but police cannot. Magistrate cannot direct the police to investigate the case in such directions. Or in some time, court cannot directed the investigation agency to include X person as an accused. It is the totally prerogative of the investigation agency whether such person is accused or not. For example, there is a FIR against 3 persons, X, Y, Z. Police is investigation officer is investigated the case, and in his final report, which is called charge sheet under section 173 of the CRPC, he filed the charge sheet against only 2 accused, and he dropped out 1 accused during the investigation. In that case, magistrate cannot direct the investigation officer to come present a charge sheet against the person which is dropped, which charges are dropped by the investigation officer in his investigation. In that case, trial start. During the course of trial, if someone deposition given against that accused which is dropped by the police during the investigation, in that case, application under section 319 of the CRPC is moved by the public prosecutor or the complainant of the advocate of the complainant. So police can, court can frame charges against that accused which is already dropped by the police investigation officer. This is the legal proposition. If anyone has any doubt, तो ask me. इंट्रोडक्शन का ही लेक्चर है, मैं तो बोलता रहूंगा, आप सुनते रहेंगे, उसका मजा नहीं आएगा। और कहीं पे मैं गलत होऊंगा तो शायद आप मुझे करेक्ट भी कर देंगे। Law is a discussion of law is a subject of discussion only.
Dear participants, because I'm also attending or witnessing the session, so I am requesting you that this is very interesting topic, that how a advocate get a case and drafting of his particular file through the investigation at FIR. Because when you will go to the court, you will find that basically the file is prepared by the investigation officer, which is called as IO. And if you are not well aware with the minute detail of the IO functioning, then you can't make your file as per your own convenience, we can say, because we don't know what side you will get as a plaintiff or as a respondent. So somewhere it is very much necessary that you should know that the functioning of the investigation and making of that registration of the FIR is very much required for the criminal proceedings. And if you will find any queries in between the session, you may ask simultaneously. Reason, it is an interactive session and we are supposed that you ask in parallel session, so that it will be an interactive session and not like a lecture method series. So thank you. Sir, please continue.
आरती शर्मा, आप बताएंगे कि arrest of the accused is necessary during the investigation? बच्चे? कोई और बताएगा? Hello?
Yes, I request to all the participants, please turn on your videos, and our resource person is wish to interact with you. There are many students who are from final year and fourth year, and they had their CRPC. And I wish that they at least attempt answer. Right or wrong is not a point. It is about that you're attempting. Sir, Ritu is mentioning that yes, it will. Deepika is mentioning no. Geeta, what is your take on at this point? Geeta?
Ma'am, please repeat the point due to network
The
issue.
arrest of the accused is necessary or not?
Arrest.
Or if yes, in what circumstances the arrest is required?
Is the arrest of the accused is mandatory in nature? And if yes, then under what circumstances it is required to do? It has to do is about after the arrest is about the bail, and if you know that is that arrest is legal or not, then only you can ask for the bail. Otherwise, it is a
after arresting the accused, the public prosecutors want his remand, and the defense counsel has argued that there is no remand required, and he moved the bail application of the accused for his release. My question is that whether arrest of the accused is necessary. If yes, in what circumstances? Yes, Simran, right, arrest is not mandatory.
Sir, if the crime committed by the accused is so heinous and the accused is harmful to the society, if the accused is not arrested, that may cause harm to the society, then his arrest is mandatory. Otherwise, he's only a suspect. He's not a proved criminal. So I think his arrest is not mandatory.
In case of heinous crime like 302, 376, generally the police firstly arrest the accused and take on his remand, so the police can collect the evidence to support the case during the trial for the conviction of the accused. The mainly purpose of the arrest is to collect the evidence. If there is a 3 accused in one FIR and police is not going to conduct any remand of the one accused, the reason being police is not going to collect any documentary evidence from him or her. In that case, arrest is not required. Police just file a challan against the accused and presenting the challan before the court. And court is duty bound to take the charge sheet and issue the summon to the accused, which is not arrested by the accused. Now, in that case, only if court deems fit, the rest of this accused is required, then police can direct the accused to surrender before the court, and police send the accused to the judicial custody. If police, the magistrate deems fit that there's no arrest is not required, and police file a charge sheet without the arresting of the accused is good, then magistrate has passed an order of bail, regular bail. This is the legal preparation. Arrest is generally required for securing the evidences.
Sir,
Yes, ma'am, please, yes, ma'am.
on this issue.
Yes.
Sir, the one participant mentioned that Section 41, the ground of arrest are mandatory grounds mentioned under Section 41 of the CRPC.
Yes.
I would like to relate this Section 41 with the Section 498 of the IPC, where the cruelty and the direct arrest was the previous provision of this issue.
Arnesh Kumar versus State of Bihar.
Right, sir. I would like to pinpoint that point that Avnish Kumar, the Supreme Court, Honorable Supreme Court, has mentioned the guidelines that again it will be the discretion of the IO before the arresting, right? So under which they are not required to make mandate in arrest.
As per our constitution, there's a moving free is a fundamental right. This judgment is based on the constitutional rights and the right of the victim too. In Aresh Karwal, generally a judgment to 498 cases को लेके आता है. There's a frivolous complaint moved by the wives and relative of the wives to harass the family of the husband. And the reason इसमें कोर्ट ने ये कहा कि भाई आपने इन्वेस्टिगेशन एजेंसी ने इश्योर करना है कि जो मदर और फादर हैं लड़के के, उनकी ननंद है, ये है, उनको तो आप अरेस्ट ना कीजिए, उनको तो आप समन करके इन्वेस्टिगेशन में ज्वाइन कराइए. और इन्वेस्टिगेशन अफसर को किसी स्टेज पे ये लगता है कि इनके द्वारा भी क्रूरटी की गई है और कोई ऐसा एविडेंस हमने लेना है, तो उसको रिमांड पे लेने के लिए अरेस्ट रिक्वायर्ड होती है जस्ट फॉर रिकवरी. इसलिए उन्होंने गाइडलाइंस पास की. और उसमें भी बड़ी डिस्प्यूट ये आया बाद में कि एक व्यक्ति ने 420 का एक चीटिंग कर ली एक्स के साथ. एक्स ने फ्लैट बुक किया, जो आजकल जनरली हरियाणा में, गुड़गांव, फरीदाबाद में बहुत हो रहा है. एक्स ने अपनी मेहनती कमाई से एक फ्लैट बुक कर लिया 25 लाख रुपए में. उस बाद में उसकी किस्तें देनी है. बिल्डर ने क्या किया, उसको ना फ्लैट दिया ना उसके पैसे वापस किए. बिल्डर आया, तब 420 में भी 7 साल से कम सजा है. बिल्डर आया, पुलिस ने उसको अरेस्ट किया और बेल पे छोड़ दिया एज पर रमेश कुमार. उस व्यक्ति को लगता है यार उसको तो न्याय नहीं मिला, वो हराश हुआ, उसके 25 लाख रुपए भी गए, उसने कंप्लेंट भी की और स्टेट एजेंसीज कैसे काम कर रही. उस केस में इन्वेस्टिगेशन ऑफिसर की ड्यूटी बनती है कि उसको अरेस्ट करे और ये कोर्ट कन्विंस करे कि इसकी अरेस्ट रिक्वायर्ड इसलिए है, इससे हमने फलां डॉक्यूमेंट रिकवर करने हैं, जो एग्रीमेंट ऑफ सेल हुआ था वो रिकवर करना है ओरिजिनल, और बाकी इसके बैंक स्टेटमेंट्स लेने, डिटेल लेनी है, और ये भी पता करना है कि इस व्यक्ति ने सिर्फ इनके साथ चीटिंग की है कि और लोगों के साथ चीटिंग की है.
Sir,
Yes, please.
I would like to know, sir, being an advocate, like our students, when they will go to the court, can they ask to the investigation officer through any proceeding about the arrest? Reason behind the arrest in such cases is not mandatory, right? And if one client is asking to the advocate that this and this an issue, and I want, so no doubt that the pleader will file a case for arrest, right? But somewhere, can there is any is there any provision where they can directly talk to the investigation officer for arrest in such issue rather than to be mandate of this free section 41?
जो कंप्लेनेंट है ना, प्रोविजन तो ऐसा कुछ नहीं है, पर बेसिक जो है कंप्लेनेंट एक बार कंप्लेंट देने के बाद एफआईआर हो जाती है, तो इन्वेस्टिगेशन ऑफिसर को प्रोवाइड करा सकता है कुछ डॉक्यूमेंट्स जो ये कहेगा कि ये फोटोकॉपीज तो मेरे पोजीशन में है, बट इसकी ओरिजिनल जो है ना इज केप्ट विद द अक्यूज्ड. सो पुलिस ऑफिसर मूव एन एप्लीकेशन बिफोर द ऑनरेबल कोर्ट फॉर टेकिंग हिम ऑन रिमांड फॉर रिकवरी ऑफ दोज डॉक्यूमेंट्स. अब इसमें एक क्वेश्चन आता है 167 सीआरपीसी ये कहता है कि जो रिमांड है ना वो अरेस्ट के ना बिल्कुल पहले 15 दिनों में ही मिलेगा. 15 दिनों के बाद आप जितना मर्जी हीनियस क्राइम हो उसमें रिमांड कभी कोर्ट ना तो आप मांग सकते ना ही कोर्ट देगा. अब क्वेश्चन ये उठा कि 15 दिन कौन से होंगे. सपोज 1 जनवरी 2022 को पुलिस ने एक बंदे एक एक्यूज को 302 के केस में अरेस्ट कर लिया और 2 तारीख को उसको पेश किया, क्योंकि 24 आवर्स में पेश करना होता है. 2 जनवरी 2022 को उसको पेश किया, तो जो पहला दिन 1 जनवरी है वो एक्सक्लूड हो जाएगा. 2 तारीख से 14 दिन चलेंगे. 14 days will be counted from the day when accused is presenting before the magistrate. और अगर हमने ये देख लिया कि पुलिस को लगता है कि 4 दिन का रिमांड मिला, उसके बाद पुलिस ने उसको जुडिशियल भेज दिया और ड्यूरिंग दैट टाइम पुलिस को 14 दिन के अंदर अंदर लगा कि इसका रिमांड दोबारा लेना है, तो दोबारा एप्लीकेशन सीक करेंगे विद सॉलिड रीजनिंग टू कन्विंस द मजिस्ट्रेट कि हमें इसका रिमांड इस स्टेज पे इसलिए चाहिए, इससे हमने कुछ और भी पता करना है, हमें कुछ नया हिंट मिले हैं. अदरवाइज 14 दिन के बाद उसको किसी भी सूरत में रिमांड नहीं मिलेगा. ये सेटल्ड लॉ है और ये स्टैट्यूट में भी क्लियर है बिल्कुल, और सुप्रीम कोर्ट ने सेटल भी किया.
Okay, sir, then there is a query on this issue that
Yes.
if one accused is out of India, then how you ask for arrest and the remand in that case?
ये 14
What
दिन
about the limitation time period?
yes, ये 14 दिन जब से स्टार्ट होंगे जब वो पुलिस की कस्टडी में होगा.
Okay, the remand is for police custody. And the participant is asking if the one wants to arrest, like we can say the Vijay Mallya case, then in that case
मैम एज पर प्रोसीजर प्रोसीडिंग चलेंगी, एक्स्ट्राडिशन की प्रोसीडिंग चलेंगी. इस केस में तो हमारी उनसे कोई संधि है या नहीं है एक्स्ट्राडिशन की, वो चीजें भी चलेंगी.
and in that case the CRPC will not help.
नहीं,
So-
definitely CRPC will help us. CRPC will help us,
Only
and
in India.
the procedure जो है ना आउट ऑफ साइड ऑफ इंडिया will also affect the CRPC. वो आपने सेक्शन 2, 3, 4 में पढ़ा नहीं है आईपीसी में कि अगर आदमी ने फॉरेन में ऑफेंस कर दिया तो वो जहां भी इंडिया में मिलेगा उसको, उसने सोनीपत में मर्डर किया और उसके बाद वो इंडिया से चला गया,
Right.
बॉम्बे में उतरता है तो उसको बॉम्बे में अरेस्ट कर सकते हैं.
And
एक व्यक्ति ने एक शिप है नेवी का, वो रजिस्टर्ड है बॉम्बे और उस पे उसने मर्डर कर दिया एक फॉरेनर्स का, तो वो इंडिया में 302 का पर्चा दर्ज होगा, उसके खिलाफ एफआईआर होगी, क्योंकि बीइंग इंडियन सिटीजन, और सेकेंडली दोनों चीजें होंगी इसमें, इंडियन सिटीजन भी है वो, और वो जो शिप है वो रजिस्टर्ड इन इंडिया, तो उसमें एफआईआर जो यही चलेगी 302 की.
okay. If it is territorial crime, in kind of, so we will check the registration of ship. If it is not extraterritorial.
शिप रजिस्टर्ड इंडिया में है, दिल्ली में या बॉम्बे में, क्राइम उसने अमेरिका में कर दिया, शिप के ऊपर होना चाहिए, पर शिप के ऊपर मर्डर कर दिया, शिप में जब वो है वहां पे मर्डर कर दिया, तो भी इंडिया में ही एफआईआर होगी और यहीं पे प्रोसीड होगा केस.
Okay, sir. Okay, sir. Thank you.
और उस केस में उसको ट्रांजिट रिमांड लेने की जरूरत नहीं है। मान लो बॉम्बे में पकड़ा जाता है और पुणे में एफआईआर उसके खिलाफ ट्रांजिट रिमांड नहीं होगा, बॉम्बे पुलिस उसको डायरेक्टली हैंड ओवर कर देगी अपना पुणे पुलिस को। ट्रांजिट रिमांड होता है, फॉर एग्जांपल ए ने अंबाला में क्राइम किया और उसके बाद जैसे उसको पता चला उसके खिलाफ एफआईआर होगी, वो वहां से निकल गया और वो शिमला में समहाउ कहीं और जाके छुप गया और हरियाणा पुलिस ने उसको वहां से अरेस्ट कर लिया। तो हरियाणा पुलिस की पहली ड्यूटी ये है कि वो लोकल मजिस्ट्रेट के सामने उसको पेश करेगी शिमला के, और वहां से उसको रिमांड पे लेगी कि इसके खिलाफ एक एफआईआर अंबाला में है, इस सेक्शन में है और हमने इसको यहाँ से अरेस्ट किया, तो हम अपने ट्रांजिट रिमांड की परमिशन दो। अगर वो परमिशन नहीं लेके आते और उसको बिना परमिशन के अरेस्ट करके लाते हैं, तो उसकी जो अरेस्ट है ना, शिमला से लेके अंबाला तक की जर्नी की, वो इलीगल अरेस्ट है।
Then there will be the wrongful restraint section IPC.
वो कंप्लेनेंट जो है, वो फिर एक्यूज जो है, उन पुलिस ऑफिसर के खिलाफ अपना अलग से लीगल कार्रवाई जो भी बनती है वो करेगा।
Okay. Sir, though we already discussed section 498A, but the participant has mentioned again the query on the issue of 498A.
क्या query है?
The query is similar, sir. What about the arrest in case of 498A? It is not a murder case. Though we discussed it already, I think
उन्होंने साफ कहा है कि जिसमें 7 साल से कम की सजा है, अरनेश कुमार जो है applicable only on those cases in which the punishment is up to 7 years. 7 साल से कम या 7 साल तक, इन those cases only. अगर 7 साल से ऊपर 10 साल की सजा है तो अरनेश कुमार की कोई वहां पे लगता नहीं। और एक ना 41A का जो आयु है जब अरेस्ट करेगा, तो 41A की एक पेपर बनाएगा, नेक्स्ट बना के जाएगा रिमांड के साथ, रिक्वेस्ट जो रिमांड की करेगा, उसमें लिखेगा व्हाई द रिमांड इज रिक्वायर्ड, व्हाई द अरेस्ट इज रिक्वायर्ड, रीजन रिकॉर्ड करेगा और मैजिस्ट्रेट भी उन रीजंस को एग्री करेगा। अगर आईओ ने ये गलती करी कि उसने ये अपना एनेक्चर नहीं लगाया और बिना एनेक्चर लगाए आईओ के अगर मजिस्ट्रेट ने रिमांड दे दिया या जुडिशियल या जैसे भी, तो दोनों ही अपने पार्ट पे इरेगुलरिटी कर रहे हैं और दोनों ही सुप्रीम कोर्ट की जजमेंट का कंटेम्प्ट ऑफ कोर्ट का वायलेशन हो रहा है।
Geeta, you may ask, you have raised your hand, and please all of you switch on your camera. I find it is very interesting session, as well as this is recorded session. So after this session, over of the session, we will share this session recording with you, and it will be a memory for future for all of you. So switch on your cameras, as well as you may interact, because I think I already mentioned in my introductory round, he is a very rich resource person with the knowledge, and he is practicing in the criminal proceeding from last 7 to 8 years, because the district attorney is supposed to deal with all the issues of Haryana. So he is a very right resource person for all such criminal proceedings. And please enjoy this session rather than to take a burden on the queries. Just enjoy the session, because I am also enjoying like a student. I am also believing that yes, this question is related to this point. So just take it easy and just enhance your knowledge with the interaction with the resource person. So I think there is another query, and Geeta, you please ask.
Thank you, ma'am. Sir, my question is, it is a general rule that investigation starts on the registering of FIR. Sir, my question is, can a police conduct preliminary investigation before the registering of FIR, or in what time they should complete the preliminary investigation? Can you please?
You are right, Geeta. As per CRPC, if the commission of offense attracts the cognizable conduct, essentials of the crime, in that case, before conducting the preliminary inquiry, it's a duty of the police firstly register the FIR. Police can, in vigilance or in CBI, police before registering the FIR जनरली जो है पुलिस जो है इंक्वायरी करती है प्रीलिमिनरी, बट अगर पुलिस की बात करें तो पुलिस की ड्यूटी है, पुलिस को अगर आए रिपोर्ट ये मिले कि एक बंदे ने कंप्लेंट दी कि मेरे भाई का मर्डर फला आदमी ने किया या मेरे भाई का मर्डर किया, मुझे शक है, उसने एक्यूज का नाम नहीं लिया कौन है, तो पुलिस की पहली ड्यूटी है एज पर ललिता कुमारी जजमेंट वर्सेस स्टेट ऑफ यूपी 2013 का जजमेंट है, कॉन्स्टिट्यूशनल बेंच जजमेंट है। इसमें सुप्रीम कोर्ट ने क्लियर कट ये कहा है कि ये बाद में देखेगी पुलिस, ड्यूरिंग द इन्वेस्टिगेशन ये पता करेगी कि क्या किस इन लोगों में से किसी ने क्राइम किया है कि नहीं किया। पुलिस की ड्यूटी है कि वो पैसों से पहले रजिस्टर्ड करे एफआईआर, फिर इन्वेस्टिगेट करे। पर आपका जो क्वेश्चन था कि प्रीलिमिनरी इंक्वायरी करती है कि नहीं करती, विजिलेंस डिपार्टमेंट जो है उसके पास कंप्लेंट आती है एक एक्स ऑफिसर की, इस ऑफिसर ने ये काम पैसे लेके किया, ये गलत किया, एज पर प्रोसीजर नहीं किया, ऐसे एलिगेशन भी ना हो पर एज पर प्रोसीजर नहीं किया, तो उन केसेस में पुलिस जो है बिफोर रजिस्टरिंग द एफआईआर एक इंक्वायरी कंडक्ट करती है, डिपार्टमेंट ऑफ इंक्वायरी, और डिपार्टमेंट इंक्वायरी कंडक्ट करने के बाद जो इंक्वायरी ऑफिसर होता है उसकी फाइंडिंग आती है और उसके ऊपर उस डिपार्टमेंट का जो भी लीगल ऑफिसर होता है उसकी राय लेके अकॉर्डिंगली एफआईआर रजिस्टर्ड करी जाती है। और एफआईआर रजिस्टर करने के बाद ही उसकी अरेस्ट होगी, क्या होगी, वो प्रोसीजर फिर सीआरपीसी से चलेगा। तीन सेक्शन सबसे इंपॉर्टेंट है इसमें, तीन, एक तो सबसे पहले पुलिस, फिर पब्लिक प्रोसिक्यूटर और जुडिशरी। क्राइम के लिए ये तीनों सेगमेंट बहुत इंपॉर्टेंट है और आप लोगों में से कल को कोई प्राइवेट लॉयर बनेगा, कोई पब्लिक प्रोसिक्यूटर बनेगा, कोई मजिस्ट्रेट बनेगा, और इंटर रिलेटेड इनकी ड्यूटीज हैं और एक विंग है ये जो आपस में मिलकर काम करते हैं। पब्लिक प्रोसिक्यूटर जो है उसका रोल बहुत इंपॉर्टेंट होता है। अब कोर्ट ने ये कहा कि कई केसेस में एक जगह मर्डर हो गया, किसी व्यक्ति को जला के मार दिया गया, आईओ ने एफआईआर दर्ज कर ली, कंप्लेंट मिल गई कि फला आदमी ने फला आदमी को जला के मारा, उसने उसकी चार्जशीट बना के कोर्ट में दी। ड्यूरिंग द इन्वेस्टिगेशन उसने बहुत बड़ी गलतियां की। उसने क्या किया, उसने जो वर्निंग क्लोथ थे वो नहीं कलेक्ट किए, सीएफएसएल में भेजे। उसने सीसीटीवी फुटेज की सीसीटीवी फुटेज था वहां पे सीन ऑफ क्राइम पे, उसने उसकी रिकॉर्डिंग लेके भी नहीं भेजी। तो जो ट्रायल कोर्ट था उसने उस बेसिस पे उसको एक्विटल कर दिया, ये इज अ डिफेक्टिव इन्वेस्टिगेशन और बेनिफिट ऑफ डाउट एक्यूज को दे। स्टेट गवर्नमेंट उसके बाद हाई कोर्ट गई, हाई कोर्ट ने ये स्ट्रक्चर पास किया कि डिफेक्टिव इन्वेस्टिगेशन के बेस पे कि आईओ ने ये डिफेक्ट किया तो हम एक्यूज को सोल बेनिफिट कभी भी नहीं दे सकते until unless the contrary is not proved. In this case, the Honorable High Court observed that the contrary is proved, that in this CCTV footage camera, that accused is burning the deceased person. Now, on the failure of IO, it's a failure of IO that he is not sent this CCTV footage to the CFSL. In that case, he convicted the accused. The reason mean कि on the defective investigation, magistrate or court cannot acquittal the accused on the basis of only defective investigation. Public prosecutor CRPC में सेक्शन 24 और 25A जो है पब्लिक प्रोसिक्यूटर के बारे में डिफाइन करते हैं। पब्लिक प्रोसिक्यूटर वो लॉयर जिसको स्टेट गवर्नमेंट अपॉइंट करती है फॉर पर्टिकुलर ट्रायल करने के लिए या सारे ट्रायल करने के लिए। पब्लिक प्रोसिक्यूटर क्या करता है, चार्जशीट कोर्ट में आ गई, चार्ज फ्रेम हो गया, चार्ज जिस दिन फ्रेम होता है उसको फर्स्ट डे ऑफ द ट्रायल बोलते हैं। द फर्स्ट डे ऑफ द ट्रायल व्हेन द चार्ज इज फ्रेमिंग अगेंस्ट द एक्यूज्ड पर्सन, ट्रायल वहीं से स्टार्ट होता है। उसके बाद विटनेसेस जाएंगे डिपोजिशन बॉक्स में, जो सरकार के विटनेस होंगे वो आए, उनको वो एग्जामिनेशन चीफ पब्लिक प्रोसिक्यूटर इन प्रेजेंस ऑफ द एक्यूज्ड एंड द काउंसिल ऑफ द एक्यूज्ड उनका डिपोजिशन होगा। देयर आफ्टर इट्स अ ड्यूटी ऑफ द डिफेंस काउंसिल टू क्रॉस एग्जामिन दोज witnesses. Now the question came, in case the witness, public prosecutor's witness hostile before the court, he reveals from earlier statement which he produced before the investigation agency that X person is guilty of the accused and I am seeing him while murdering. But in contrary, अगर उसको कोर्ट में आके कहता है कि नहीं मैंने इसको मर्डर करते हुए नहीं देखा, तो पब्लिक प्रोसिक्यूटर उसको कोर्ट से रिक्वेस्ट करेगा कि इसने अपनी पुरानी स्टेटमेंट से मुकर गया. He is revealed from his earlier statement. So kindly give me a permission to hostile this witness and cross examine. उस केस में पब्लिक प्रोसिक्यूटर क्रॉस एग्जामिन करेगा और इन जनरल केस में डिफेंस लॉयर जो है वो क्रॉस एग्जामिनेट करता है डिफेंस विटनेस का. इस केस में वो पब्लिक प्रोसिक्यूटर को उसको सारे क्वेश्चन पुट करेगा, उसकी जो स्टेटमेंट है 161 की उसके कंट्रारी करेगा कि आपने ये कहा था, इट इज रॉन्ग टू सजेस्ट दैट कि आपने ये कहा था उस टाइम पे, आप अब ये कह रहे हैं. तो ये उसके बाद अक्यूज को भी बहुत राइट दिए गए हैं सीआरपीसी में. जब पूरा ट्रायल कंक्लूड हो जाएगा, सारे डिपोजिशन हो जाएंगे, तो अक्यूज की 313 की एक स्टेटमेंट होगी और वो विदाउट ओथ होती है, उसको ओथ पे नहीं लेते. अगर अपनी उस स्टेटमेंट में वो कुछ गलत भी बोल ले तो उसके खिलाफ 340 आईपीसी की प्रोसीडिंग नहीं चल सकती, सीआरपीसी की, सॉरी 340 सीआरपीसी की प्रोसीडिंग नहीं चलती. 340 सीआरपीसी ये है कि कोई व्यक्ति अपनी इच्छा से, उसको पता है कि ये बात गलत है, फिर भी कोर्ट में झूठ बोल रहा है, तो उसके खिलाफ कोर्ट सुओ मोटो 340 की एप्लीकेशन चलाता है. 313 की जो स्टेटमेंट होती है अक्यूज की, वो विदाउट ओथ होती है. उसमें अक्यूज अपना वर्जन कोर्ट को बता सकता है कि नहीं मैंने नहीं किया. मैं तो प्ली ऑफ एलिबाई ले सकता है कि भी मैं उस दिन एट द डे ऑफ क्राइम आई एम नॉट इन इंडिया, आई एम नॉट इन दिस सिटी. प्ली ऑफ एलिबाई अपने डिफेंस में लेके आ सकता है. जो भी उसके पास उसके फेवर के डॉक्यूमेंट हैं, एविडेंसेस हैं, उनको वो उसमें अपनी स्टेटमेंट में रिकॉर्ड करा सकता है. और कोर्ट उस स्टेटमेंट से रेफरेंस ड्रॉ कर सकता है फॉर द कन्विक्शन ऑफ द अक्यूज्ड. ये बहुत इंपॉर्टेंट स्टेटमेंट है. और अगर किसी स्टेटमेंट, किसी ट्रायल में ये स्टेटमेंट नहीं होती तो सुप्रीम कोर्ट ये कहता है कि ये ट्रायल ही विशिएट है, वो प्रोसीडिंग ही कंप्लीट नहीं है. एक बच्चे एक होता है कि विड्रॉल ऑफ प्रोसिक्यूशन, आपने सुना होगा फाइनल ईयर के जो बच्चे होंगे, सेक्शन 320 सीआरपीसी.
यस सर.
321 सॉरी, विड्रॉल ऑफ प्रोसिक्यूशन सुना है आपने?
Yes, sir. Yesterday we had some discussion on it.
क्या होता है विड्रॉल ऑफ प्रोसिक्यूशन? कोई हिंट, कोई वैसे आइडिया लीजिए, मैं तो बताऊंगा आपको. Withdrawal of prosecution.
Sir,
Yes. Go ahead.
withdrawal from prosecution means कि जो public prosecutor होता है और with the consent of the court, he withdraw the charges. The charges.
Okay. One or more of the charges. Ne? विड्रॉल ऑफ प्रोसिक्यूशन में जैसे अभी जाट आंदोलन हुआ, अभी किसान आंदोलन हुआ, तो जो लोगों ने बाइज लॉज का वायलेशन किया उनके खिलाफ एफआईआर दर्ज हुई डिफरेंट लोगों का. फिर गवर्नमेंट ने डिसीजन लिया कॉम्प्रोमाइज बेसिस पे कि भी हम इसकी विड्रॉल ऑफ प्रोसिक्यूशन करेंगे. तो गवर्नमेंट ने इंस्ट्रक्शंस पास किए डिस्ट्रिक्ट अटॉर्नीज ऑफिस को फील्ड के कि एप्लीकेशन मूव कीजिए बिफोर द ऑनरेबल कोर्ट फॉर विड्रॉल ऑफ द प्रोसिक्यूशन. पब्लिक प्रोसिक्यूटर ने विद रीजन वो एप्लीकेशन मूव करनी है बिफोर द कोर्ट, और ये किसी भी स्टेज पे की जा सकती है बिफोर पासिंग द जजमेंट. ये बड़ा इंपॉर्टेंट है, ये किसी भी स्टेज पे की जा सकती है बिफोर प्रोनाउंसमेंट ऑफ द जजमेंट. इन दैट केस कोर्ट ये डिसाइड करेगा, कोर्ट उसको एक्सेप्ट करेगा और नहीं करेगा वो कोर्ट का प्रेरोगेटिव है. पर 99% कोर्ट केसेस में कोर्ट इसको जनरली एक्सेप्ट ही करता है। तो बहुत बड़ी पावर है। वैसे तो पब्लिक प्रोसिक्यूटर इस पावर का यूज करता है इन द डायरेक्शन ऑफ द गवर्नमेंट, बट एज पर सीआरपीसी और द जजमेंट पास बाय द ऑनरेबल सुप्रीम कोर्ट के पब्लिक प्रोसिक्यूटर कैन use this power by applying his own mind or in any case। इंडिया में ये प्रैक्टिस नहीं है कि पब्लिक प्रोसिक्यूटर ये पावर अपने इंडिपेंडेंट माइंड से अप्लाई करता है। अदरवाइज इन यूएसए इट्स अ जनरल प्रैक्टिस कि गवर्नमेंट कभी पब्लिक प्रोसिक्यूटर को डायरेक्शन नहीं देती कि इस केस में हमने विड्रॉल करना है। जहां पे पब्लिक प्रोसिक्यूटर को ये लगता है कि ये केस कन्विक्शन की तरफ नहीं जा सकता और ये जो प्रोसीडिंग्स हैं बिल्कुल जो हम ट्रायल चला रहे हैं उसमें जो एविडेंसेस हैं इतने वीक हैं कि हम एक्यूज्ड की कन्विक्शन सिक्योर नहीं कर सकते, प्रूव नहीं कर सकते, तो वो उसको ड्रॉप कर। और कोई सवाल मैडम किसी का बच्चे का? मुझे लग रहा है लेक्चर काफी बोर हो गया।
No, sir. It is very interesting session. As well, sir, आप अभी withdrawal of prosecution की बात कर रहे थे. So I just want to add something in the same. Sir, in the criminal cases, we have the title I A versus state of Haryana, B versus state of Haryana, right? So I just want to know that in case of, because you were mentioning also that benefit of doubt and in the default of investigation, right? So in the case of default on investigation, if the accused is feeling like, or the person is feeling like victim, so can they ask for the compensation as a victim, like DK Basu case and the case of habeas corpus?
357A CRPC compensation provision is there. Court can pass the compensation while deciding the case. In both
so who will bear the loss, basically? Who will bear the loss because of the abuse of power by the police officer? Who will bear the loss? The police officer personally or the state?
State.
State.
Now, yes. State. It's a duty of the state. It's a duty of the state to recover that compensation from the pocket of the erring official.
But it will be given by the state to the victim.
Yes.
Okay.
रेप केसेस में और क्राइम अगेंस्ट वीमेन केसेस में तो गवर्नमेंट ऑफ हरियाणा, गवर्नमेंट ऑफ इंडिया ने एक अलग से ट्रेजरी अकाउंट बना रखा है। उस अकाउंट से जो कोर्ट पास करता है उस अकाउंट से उनको पे होता है। और इट्स द प्रेरोगेटिव ऑफ द गवर्नमेंट कि उसके बाद वो उनसे जो एरिंग ऑफिशियल है जिसके पार्ट पे वो एरर हुआ उससे वो रिकवर कर सकते हैं। और इन सम केसेस जनरली कोर्ट राइट भी कर देता है कि जो ये पैसा है इसकी पॉकेट से लिया जाए सैलरी से।
So sir, do the police officers have such kind of accountability? They fix with their accountability. Then in case of abuse of power, they with the disciplinary action.
In Haryana, Supreme Court, in Honorable Supreme Court passed a judgment in 2014.
Okay.
Kishan Bhai versus State of Gujarat.
Right, sir. This is very, very recent, important judgment.
Right? On the basis of this committee, at district level, the committee is constituted in which a deputy commissioner is chairman, district attorney is a member secretary, and superintendent of police of that district is a member. ये तीनों लोग बैठ के पब्लिक प्रोसिक्यूटर के पार्ट पे क्या लैप्स रहा, आईओ के पार्ट पे क्या लैप्स रहा, उसको डिसाइड करते हैं। और इस कमेटी की जो ऑब्जर्वेशंस है वो होम सेक्रेटरी के पास जाती है। और ये कमेटी
kind of proceedings against the
erring officials during the trial and during the investigation as well.
So
मान लो ये केस में इन्वेस्टिगेशन बहुत अच्छी हुई, बट पब्लिक प्रोसिक्यूटर की गलती, पब्लिक प्रोसिक्यूटर ने उस इन्वेस्टिगेशन को अच्छे से प्रेजेंट ही नहीं किया कोर्ट में, तो एरिंग तो वो भी है।
This is also abuse of power.
जैसे मैं मानता हूँ कि एक सेट के 4 गवाह हैं, सेट का मतलब एक जैसी स्टेटमेंट है, ए बी सी डी, ये कहते हैं कि मैंने भी देखा इसको, मैंने भी देखा, मैंने भी देखा, मैंने भी देखा। हम चारों वहां पे थे मर्डर के टाइम पे, जब मर्डर हुआ हमने चारों ने देखा। तो पब्लिक प्रोसिक्यूटर की ड्यूटी है, मान लो मैं पब्लिक प्रोसिक्यूटर हूँ उस ट्रायल का, तो मैं 2 विटनेसेस को कराऊंगा ए और बी, उन्होंने मेरे को सपोर्ट कर दिया कि हमने देखा सर, इसको हमने देखा, और पूरी मेरी वो जो स्टेटमेंट है बिल्कुल ठीक है, मुझे लग रहा है कि मैं इसमें कन्विक्शन सिक्योर कर लूं, तो मैं सी और डी को कभी नहीं कराऊंगा, मैं इनको गिवन अप कर दूंगा। मेरे पास पावर है, पब्लिक प्रोसिक्यूटर के पास पावर है एज पर प्रोसीजर, उसको गिवन अप कर सकते हैं। अगर मान लो मैं चारों व्यक्तियों को उनकी डिपोजिशन कराऊं और फिर उसमें कंट्रेरी व्यू आए जिसका बेनिफिट एक्यूज को मिले, वो गलत है मेरे पार्ट पे। जब मैंने देखा कि चार आदमी की एक जैसी स्टेटमेंट है, ये एक जैसी विटनेस है, इनका एविडेंस सेम, इनका एविडेंस आ रहा है, तो मेरी ड्यूटी बनती है कि सिर्फ मैं दो को कराऊं, जो और दो को मैं गिवन अप कर दूं, गिवन अप बीइंग अननेसेसरी एट दिस स्टेज। वो ट्रायल कंडक्ट करने की ब्यूटी है। हाँ, मैं चारों को करा दूं और उसमें फिर कॉन्ट्रैरी वर्जन्स आ जाएं और उसकी वजह से वो उनमें बाद में कहे जी नहीं नहीं धुंधला धुंधला था शाम को वहां पे, तो जब मैंने देखा ये नहीं था जी, नहीं नहीं उसने तो लाल टी शर्ट नहीं डाल रखी थी जी, तो वो कोर्ट के माइंड में सस्पेक्ट आ गया कि भाई नहीं, और जो एक्यूज के वकील को पॉइंट मिल गया। तो पब्लिक प्रोसिक्यूटर की भी बड़ी ड्यूटी है इसमें, मेजर रोल ये है कि भाई वो डिफेक्टिव, कई बार इन्वेस्टिगेशन बहुत अच्छी होती है, पब्लिक प्रोसिक्यूटर की वजह से केस खराब हो जाता है। जो ये स्टेट ऑफ गुजरात केस है, ये केस पब्लिक प्रोसिक्यूटर की वजह से खराब हुआ।
ओके, दिस वाज बिकॉज़ ऑफ,
और इसमें सिर्फ इन्वेस्टिगेशन ऑफिसर का एक ही एरर था, तो कोर्ट ने 3 जजेस बेंच ने, जस्टिस खेर चीफ जस्टिस थे, उन्होंने पास किया जजमेंट। ये उन्होंने ये लिखा कि पैरा 19 इन जजमेंट, जब पुलिस एक चलान ले आती है बना के, तो उसको चलान की जो स्क्रूटनी करेगा वो पब्लिक प्रोसिक्यूटर ऑफिस करेगा, डिस्ट्रिक्ट अटॉर्नी ऑफिस। डिस्ट्रिक्ट अटॉर्नी ऑफिस उसकी स्क्रूटनी करके इसको इम्प्रूव करेगा कि इसमें ये कमी है, ये कमी है, ये स्टेटमेंट लिख के लाओ, इसमें ये एविडेंस नहीं है, ये कलेक्ट करो, ये करो, ये करो, डायरेक्शन देगा। और इन्वेस्टिगेशन ऑफिसर की ये ड्यूटी है कि उन डायरेक्शन को कंप्लाई विद करेगा। अगर उसने उसको कंप्लाई विद नहीं करा तो डिस्ट्रिक्ट अटॉर्नी उस स्टेज पे भी चाहे तो उस केस को ड्रॉप कर सकता है विद कमेंट कि भी ये एयरिंग ऑफिशियल ने ये काम नहीं किया और ये केस प्रूव नहीं हो सकता।
so we can say that you have a very wide powers given by the CRPs, right?
So power come with duties.
With
Duties
duties, along with duties. That's very true. Sir, there is a query from Sonia Sharma. She is asking which deal with appointment of presiding officer of session court.
Pardon, please.
Which deal with appointment of presiding officer of session court. She is asking that section 9 subsection 2 of CRPC, it's connected with the article 233 of the constitution, which is dealing with the appointment of presiding officer of session court. Sonia, if you are present in this session, please correct me if I am mentioning something else, because I can read only these two.
Yes, ma'am.
ADJ की जो appointments हैं वो,
explain your question because I am also not able to understand it. Sonia, please elaborate your question.
Yes, ma'am. First of all, good afternoon, sir. Good afternoon, ma'am. Sir, my question is this कि section जो 9 है CRPC का, जिसका clause 2 deal करता है कि जो appointment है presiding officer की of court of session कि इसको appoint करेगा high court.
Yes.
वहीं पे जो आर्टिकल 233 है वो डील करता है कि ये जितने भी डिस्ट्रिक्ट कोर्ट के जजेस हैं, प्रिसाइडिंग ऑफिसर्स हैं, उनको गवर्नर अपॉइंट करेगा। तो सर एज वी नो कि कॉन्स्टिट्यूशन ग्रांड नॉर्म है, तो सीआरपीसी कैसे ओवरराइड कर रहा है, क्योंकि यहाँ बोला गया और नीचे जो एक्सप्लेनेशन है वहाँ पे अपॉइंटमेंट के बारे में भी बात की गई है कि फर्स्ट अपॉइंटमेंट के साथ। मैं थोड़ा सा कंफ्यूज हूँ।
राइट, मैं क्लियर करता हूँ आपको। जो एडीजेस की डायरेक्ट रिक्रूटमेंट होती है और क्या प्रमोशन से जाएंगे, जो भी सेशन जज, मजिस्ट्रेट से सेशन जज बनते हैं, अपॉइंटमेंट जो है ना वो गवर्नमेंट देती है हमेशा ऑन द बिहाफ ऑफ गवर्नर। कोई भी काम होता है वो गवर्नर के नेम से होता है। मेरा ट्रांसफर होगा एक जिले से दूसरे जिले में, तो यही लिखा हुआ होगा कि गवर्नर ऑफ हरियाणा इज प्लीज्ड टू ट्रांसफर यू फ्रॉम दिस प्लेस टू दिस प्लेस। और जो रिक्रूटमेंट है इनकी हाई कोर्ट जज, इनकी मजिस्ट्रेट्स की या एडीजेस की, वो जो रिक्रूटमेंट्स हैं एज पर दी न्यू रिक्रूटमेंट रूल्स 2009 में अमेंड हुए, उन रूल्स के हिसाब से जो उनके अपॉइंटमेंट्स है वो हाई कोर्ट करता है। और उस रिक्रूटमेंट में जो चेयरमैन एचपीएससी भी बैठता है इंटरव्यू में, और हरियाणा सरकार का चीफ सेक्रेटरी भी और एडवोकेट जनरल भी इन केस ऑफ मजिस्ट्रेट्स अपॉइंटमेंट इंटरव्यू में। पर वो सारा जो प्रोसीजर है उसको हाई कोर्ट ही वॉच करता है। हाई कोर्ट तो सिलेक्ट करके भाई ये व्यक्ति हमने सिलेक्ट कर लिया, लिस्ट गवर्नमेंट को भेज देता है। गवर्नमेंट एक रजिस्टर है, रजिस्टर नंबर 19, उसी में उसको रजिस्टर करता है, और रजिस्टर करने के बाद उनको अपॉइंटमेंट लेटर देता है।
Okay, sir. Thank you so much, sir. And one more thing I want to know, sir, कि हम जो CRPC हम उसको एविडेंस के साथ, एविडेंस एक्ट के साथ और कॉन्स्टिट्यूशन के साथ डील करके पढ़ सकते हैं। कोई और भी एक्ट है क्या सर कि जिसके साथ लाइक लिमिटेशन हो गया, एविडेंस हो गया, कॉन्स्टिट्यूशन तो बिल्कुल ही कनेक्टेड है।
अपने आप में कंप्लीट एक्ट है और कंकरेंट लिस्ट का सब्जेक्ट है, तो इसमें स्टेट भी अपने तरफ से अमेंडमेंट कर सकती है।
Yes sir, also like कि जो अरेस्ट की प्रोविजन है वो also connected with आर्टिकल 20 का।
किसी एक्ट में बच्चे स्पेसिफिकली मेंशन किया गया प्रोसीजर।
हाँ जी सर।
कोई मान लो ऑफेंस है, जैसे कोई एनडीपीएस है फॉर एग्जांपल।
यस सर।
एनडीपीएस में अगर इन केस कह दें कि उन्होंने अपना प्रोसीजर अरेस्ट का दे दिया, ये अरेस्ट का प्रोसीजर रहेगा, ये रहेगा। जैसे सीआरपीसी में तो ये लिखा हुआ है ना कि 60 दिन में फला केस में अगर चार्जशीट नहीं आई तो एक्यूज को बेल मिल जाएगी, डिफॉल्ट बेल, और 90 दिन में नहीं आई तो मिल जाएगी। अब एनडीपीएस में कुछ केसेस में वो 180 दिन का प्रोविजन है, तो वो एनडीपीएस में चलेगा। स्पेशल एक्ट में अगर वहीं पे प्रोसीजर मेंशन कर दिया गया है तो वो प्रोसीजर चलेगा उसी एक्ट से। अगर वहां पे प्रोसीजर नहीं दिया गया फिर वो सीआरपीसी से चलेगा।
ओके सर। सर मैं तो जस्ट ये जानना चाह रही थी कि अगर हम जुडिशरी की पर्पज से अगर हम इसको कनेक्ट करके पढ़ना चाहें या फिर अपनी और ज़्यादा नॉलेज इंक्रीज करना चाहें तो हम सीआरपीसी को कॉन्स्टिट्यूशन के साथ, एविडेंस एक्ट के साथ या फिर अदर कोई चीजें जो मैं मिस कर रही हूँ कि
कॉन्स्टिट्यूशन ज्यादा पढ़ सकते हैं। राइट ऑफ एक्यूज्ड कॉन्स्टिट्यूशन से आए, राइट ऑफ द विक्टिम भी कॉन्स्टिट्यूशन से आए।
एक्जेक्टली सर।
क्राइम अगेंस्ट स्टेट इसलिए तो बोला गया, कॉन्स्टिट्यूशन की वजह से इसको क्राइम ऑफ स्टेट बोला गया। मालूम मर्डर तो होता है एक एक्स फैमिली के बंदे का, तो एक्स वर्सेस एक्स वाई होना चाहिए था, इसलिए वाई ने मर्डर किया, बट वो होता है वाई स्टेट वर्सेस वाई।
यस सर।
So it is a crime against the state.
Yes. Okay, sir. Okay. Thank you so much, sir.
Okay.
And so one more thing I want to know.
Yes, please go ahead.
Yes, sir. It has been mentioned in section 46 of CRPC, in clause 4, कि कोई भी वुमेन जो है वो आफ्टर सनसेट और बिफोर सनराइज अरेस्ट नहीं की जाएगी, बट वेयर एज वी टॉक अबाउट द एक्सेप्शनल सर्कमस्टांसेस वहां पे अरेस्ट की जा सकती है, बट सबसे पहले उसको रिटर्न रिपोर्ट लेनी पड़ेगी फॉर द जुडिशियल मजिस्ट्रेट ऑफ द। बट सर इफ वी टॉक अबाउट अगर रात हो चुकी है और बहुत ज्यादा कोई सेंसिटिव ऑफेंस किया है उस लेडी ने, जो कि विच इज नॉट गुड फॉर एट एनी कॉस्ट गुड फॉर सोसाइटी, तो सर उन सर्कमस्टांसेस में अरेस्ट किया जा सकता है, क्योंकि अगर वहां पे वुमेन ऑफिसर भी प्रेजेंट नहीं है तो क्या सर मेल ऑफिसर उस लेडी को अरेस्ट कर सकता है क्या?
With the permission of the Ilaka magistrate and the fact brought to in the knowledge of the Ilaka magistrate that this is the situation.
Okay.
In that particular stances, the magistrate can pass an order and appoint even an executive magistrate or someone even के इसकी supervision में करो तो कर सकते हैं।
Okay, sir.
ये स्टेट ऑफ राजस्थान का केस था, उसके बाद ये अमेंडमेंट होके प्रोविजन आया था, उससे पहले तो कर लेते थे अरेस्ट। उन्होंने कहा कि नहीं सनसेट के बाद ही, और स्पेशली इन द प्रेजेंस ऑफ द फीमेल ऑफिसर। हाँ, इस पे मैं आपको जजमेंट भी है, वो जजमेंट मैं आउट कर दूंगा मैम रोल साहब को, तो इनसे आप कलेक्ट कर लेना।
ओके सर। ओके सर, मेरा एक क्वेश्चन और है।
प्लीज
सर जो सेक्शन 2 है, 2 का पी विच डील विद द प्लेस, जो इंक्लूड करता है हाउस को, बिल्डिंग को, टेंट को, वहीं पे बात करें ये व्हीकल और वेसल को भी कर रहा है। और सर वहीं पे आईपीसी की बात करें तो जहाँ पे डील करता है प्लेस के साथ 378 में आईपीसी के आई थिंक ये है जो थेफ्ट से डील करता है, तो वो बताता है कि प्लेस में क्या क्या है। वहाँ पे प्लेस में आईपीसी में सिर्फ हाउस, बिल्डिंग और टेंट को मेंशन किया गया है, व्हीकल और वेसल को।
विजुअल टेंट।
हाँ जी सर।
विजुअल टेंट ना बच्चे, वो उसका ना पर्पस अलग हो गया, मैं आपको बताता हूँ।
ओके
अब
सर।
एक मूविंग कार में एक लड़की के साथ रेप हो जाता है, ठीक है।
ओके सर।
इन दैट केस कार इज द प्लेस,
हम्म।
और एक घर से चोरी हो जाती है, वो घर तो प्लेस है ही। पर्पस जैसे ही इंटेंशन क्या है, व्हाट इज द इंटेंशन ऑफ द लेजिस्लेचर बिफोर बिहाइंड इनेक्टिंग द प्रोविजंस, इट्स मैटर। अब जैसे मैं आपको एक छोटा सी बात बताता हूँ, इंग्लैंड में ना एक सेक्सुअल ऑफेंडर एक्ट 1930 आया, तो वहां पे जो प्रोस्टिट्यूट थी वो अपनी स्ट्रीट में अपनी बॉडी को सेल करने के लिए खड़ी रहती थी, तो उन्होंने एक्ट पास करके उसको पनिशमेंट कर दी कि जो यहाँ पे ये एक्ट करेगा स्ट्रीट्स में तो उसके खिलाफ 5 साल की सजा होगी। प्रोस्टिट्यूट्स ने क्या किया, वहीं पे घर थे उनकी विंडोज में चली गई और वहां से कस्टमर को अटैक करना शुरू कर दिया। The question again came before the House of Lords. The basic purpose of that is defeated. In that case, House of Lords ने कहा कि balcony is not a part of the house, but if the women are selling themselves from the balcony, in that only those purpose, balcony included in the street. बालकनी इज नॉट अ पार्ट ऑफ स्ट्रीट, बट इस पर्पस के लिए स्ट्रीट का पार्ट बना दिया।
तो सर क्या हम ये कह सकते हैं कि सीआरपीसी वाइड रेंज में बात करता है अगर कंपेयर किया जाए आईपीसी के साथ, क्योंकि आईपीसी में व्हीकल और
बच्चे आईपीसी में तो ना ऑफेंसेस है, प्रिवेंशन क्या है, ऑफेंसेस क्या है, वही है, और प्रोसीजर क्या है, उस ऑफेंस को ट्रायल कैसे चलना है, उसको इन्वेस्टिगेट कैसे करना है, वो सारा प्रोसीजर सीआरपीसी में दिया हुआ है।
ओके सर।
वो तो सब्सटेंटिव लॉ है, ये प्रोसीजर लॉ है।
यस यस,
इनमें बड़ा फर्क ही है। आपको पूरे सीआरपीसी में पनिशमेंट कहीं नहीं मिलेगी।
यस सर, इट्स जस्ट डील विद द प्रोसेस सर।
प्रोसीजर बताया गया है, क्राइम हो गया उसकी इन्वेस्टिगेट कैसे होगी, उसका ट्रायल कैसे होगा, एक्विटल के बाद अपील कैसे होगी, कन्विक्शन के बाद प्रोसीडिंग कैसे होंगी, पैरोल कैसे होगा, वो सारी चीजें डिस्कस की गई है।
ओके सर।
तो इंटेंशन भी देखनी है लेजिस्लेचर की ना, लेजिस्लेचर ने फला प्रोविजन जोड़ा तो उसकी इंटेंशन क्या है। जैसे आप एक 299 पढ़ते हैं,
यस सर।
मैं आपसे क्वेश्चन पूछता हूँ, एक प्रेग्नेंट वीमेन का मर्डर कर देता है एक बंदा,
यस सर।
तो आप मुझे बताओ कि उसको 2 मर्डर के लिए प्रोसिक्यूट करेंगे या सिंगल मर्डर के लिए प्रोसिक्यूट?
सिंगल के लिए, अगर वो प्रेग्नेंट है, अगर अभी बेबी डिलीवर नहीं हुआ है तो डील विद द होम।
अच्छा मेरा क्वेश्चन यही है, वो प्रेग्नेंट लेडी है,
यस सर, वो एक के लिए चार्ज होगा,
ठीक है ना, बट बेटा 315 भी लगेगी ना।
यस मिस,
उसको अगर पता है कि प्रेग्नेंट है फिर भी गोली मार रहा है,
यस यस,
बट क्यों? आप 299 आईपीसी की एक्सप्लेनेशन देखो, उसने कहा था मदर इन चाइल्ड वूम इज नॉट फॉर विद,
यस
जब वो वूम में है तो वो वूम है, द मोमेंट वो बाहर आता उसका एक भी स्टेप तो सिंगल, तो वो 2 के लिए मर्डर होता। पर ये उसको पावर कहाँ से मिली? आप सेक्शन बच्चे 6 और 7 पढ़ो आईपीसी का, वो ये कहता है कि जो एक्सप्लेनेशन में कह दिया गया वो भी एब्सोल्यूट है, जनरल प्रोविजन के अगर अगेंस्ट एक्सप्लेनेशन। तो आप जब दोबारा पढ़ेंगे 6 और 7 आईपीसी का ध्यान से पढ़ना, तो आपको ये क्लियर होगा कि एक्सप्लेनेशन की कितनी वैल्यू इस सेक्शन ने की है, वो सेक्शन 6 और 7 ने की।
ओके सर, आई विल गो फॉर दिस। कोई और नहीं पूछ रहा, मैं ही पूछ लूं क्या मैम?
There are many hand raised. If you have any thirst, you may ask. You may ask.
ये लास्ट क्वेश्चन होगा, उसके बाद मैं थोड़ी देर बाद पूछूंगी।
Okay. Okay.
Sir, section 155 deal with the non-cognizable offenses. We deal with the like कि अगर कोई पुलिस ऑफिसर विदाउट द पावर ऑर्डर ऑफ द मजिस्ट्रेट अरेस्ट नहीं कर सकता, बट वहीं पे इसके साथ एक्सेप्शन मैंने रिलेट की, शायद मैं गलत भी हो सकती हूँ, कि जो सेक्शन 42 है सीआरपीसी का, वहाँ पे मुझे लगता है ये एक्सेप्शन है नॉन कॉग्निजेबल ऑफेंस।
नॉन कॉग्निजेबल ऑफेंसेस में ना एफआईआर दर्ज नहीं होती विदाउट द ऑर्डर ऑफ द कोर्ट।
यस सर।
नॉन कॉग्निजेबल
और अरेस्ट भी नहीं किया जा सकता,
अरेस्ट भी विद द परमिशन ऑफ द कोर्ट।
यस 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 सर। मैं ये पूछ रही हूँ आपसे कि जो सेक्शन 155 है, क्या उसकी एक्सेप्शन सेक्शन 42 भी 2 है क्या? जो
155 की जो एक्सेप्शन है, 42 क्या बोल रहा है, बताना मेरे को एक बार।
it will deal with the arrest on refusal to give name and residence.
नहीं, वो एक्सेप्शन नहीं।
तो सर उसने तो कोई ऑफेंस नहीं किया है ना, जस्ट पुलिस ऑफिसर
नहीं,
जस्ट
प्रिवेंटिव एक्शन में ना बच्चे, प्रिवेंटिव एक्शन में आप आर्टिकल चले जाओ ना, कॉन्स्टिट्यूशन पे आ गए ना। अब आप आर्टिकल में आ जाओ कि हम प्रिवेंटिव एक्शंस में भी अरेस्ट करते हैं ना। अब किसी को पता चल जाए, किसी को मारेगा, ये रिपोर्ट चली जाए
सस्पेंशन की बेस पे,
प्रिवेंटिव एक्शन के।
यस सर।
तो पुलिस को ये इन्फॉर्मेशन मिल गई तो पुलिस पहले आके मुझे प्रिवेंट कर लेगी, अरेस्ट नहीं करेगी, वो प्रिवेंट होगा कि आप घर से बाहर नहीं निकलेंगे जी आज।
यस सर, बट ये तो जस्ट एक छोटा सा ऑफेंस तो नहीं कहा जाएगा, बट ये तो जस्ट ये है कि उससे पूछा गया है, वो कोऑपरेट नहीं कर रहा है, वो गलत नाम बता रहा है,
वो गलत नाम बता रहा है तो अरेस्ट कर लेगी।
इंटेलिजेंस
फैक्ट आ गया ना कि हो सकता है ये बड़ा क्रिमिनल हो, कोई किसी केस में संदिग्ध हो, वो इसकी एक्सेप्शन नहीं है बच्चे।
बट सर हम रिलेट कर सकते हैं क्या? मैं थोड़ा सा कंफ्यूज हूँ, अगर आप इफ दिस इज पॉसिबल फॉर यू टू गो थ्रू विद दिस, प्लीज सर हेल्प मी आउट विद इट।
नहीं बच्चे, मेरे हिसाब से इसको नहीं कर सकते, वो डिफरेंट प्रोविजन है, ये बिल्कुल डिफरेंट प्रोविजन है।
ओके सर।
और जैसे 156(3) पढ़ेंगे ना, मान लो आप पुलिस के पास गए, आपने कहा कि फला आदमी ने हमारे घर पे चोरी की या कुछ भी किया, भाई हमारा सिलेंडर उठा के ले गया या फिर मेरे को तंग किया, और पुलिस उस केस में एफआईआर दर्ज नहीं करती, जो आपका वर्जेबल है। तो आप कोर्ट में मूव एप्लीकेशन करते हैं अंडर सेक्शन 156(3)
के अंदर,
और लॉजिंग एफआईआर।
सर एंड उससे पहले हम 154 के 3 में भी जा सकते हैं एसपी के पास।
नहीं, वो तो एसपी के पास जाएंगे ना, वो प्रोसीजर छोड़ के, मान लो पुलिस ने डिनाई कर दिया फ्रॉम द बॉटम टू द टॉप।
ओके, अगर पुलिस ने मना कर दिया, एसपी की जगह हम डायरेक्ट 156 के 3 में जा सकते हैं।
हाँ जी, हम 156(3) में जाके कोर्ट में कह सकते हैं कि यही बात है कि एफआईआर दर्ज की जाए। कोर्ट उसमें एफआईआर दर्ज करने के ऑर्डर कर देगा, सब्सटेंस देखने के बाद, चेक करने के बाद
लगेगा, जब भी तो कोर्ट उसमें ऑर्डर करेगा एफआईआर के। अगर कोर्ट को लगेगा कि वो है ही नहीं उससे तो फिर वो एफआईआर के लिए 205 में डिनाई कर देगा और 204 में उसको एक्सेप्ट कर लेगा।
मैं बताता हूँ बच्चे, आप गुड, वेरी गुड। कोर्ट को लगेगा तो एफआईआर कर देगा, कोर्ट को नहीं लगेगा ना तो कोर्ट उसको 202 में प्रोसीडिंग चलाएगा।
यस सर, फिर 190 की कॉग्निजेंस भी तो लेगा ना।
190 की कॉग्निजेंस
बच्चे पहले वो उसको 190 कॉग्निजेंस बाद में लेगा, वो जब ऑर्डर करेगा एफआईआर के ना तब तो कॉग्निजेंस ले करेगा। अगर उसने उसको लगा कि मैं इसको 202 में कंप्लेंट चलाता हूँ तो कॉग्निजेंस नहीं लेगा।
सर
अगर 156(3) में लेगा बट 200 में तो नहीं लेगा ना सर। अगर मान लो उसको कोर्ट को लगता है कि हाँ इसमें एफआईआर रजिस्टर्ड होनी चाहिए,
फिर उसको 204 में चलाएगा ना।
जी सर।
जब उसने ये मान लिया कि इसको एफआईआर होनी चाहिए तो वो सिंपल क्या करता है, कोर्ट 156 में ऑर्डर करके एसएचओ कंसर्न को भेज देता है कि एफआईआर दर्ज करके कोर्ट को कॉपी भेज देता है कंप्लायंस द ऑर्डर। और अगर कोर्ट को लगता है कि नहीं, और ये याद रखना कि 156(3) में जब आप डालते हैं एप्लीकेशन बिफोर द कोर्ट फॉर लॉजिंग द एफआईआर, रिक्वेस्ट फॉर लॉजिंग द एफआईआर, इस केस में अगर पुलिस से रिपोर्ट मांग ली कोर्ट ने तो 204 में मांगेगा। अगर उसने बिना रिपोर्ट पुलिस की मांगे 202 में प्रोसीडिंग चला दी, फिर वो कंप्लेंट केस हो जाएगा। You got my point?
Yes sir.
ये है बच्चा वो प्रोविजन ना।
Okay. Sir, you are talking about 156(3). It's 154(3).
बट 154(3) जो है वो सुपरिटेंडेंट की बात है, सुपरिटेंडेंट पुलिस की बात कर रहा है वो।
Sir, if under 154(1), if the
मैं वही कह रहा हूँ बच्चे कि
if it is denied by the police,
तो वो सुपीरियर
then we
ऑफिसर जाएगी एसपी के पास
under 154(3).
हाँ, ये 154(3) में उसकी रजिस्टर्ड एफआईआर। इन दैट केस 156(3) में कोर्ट के पास आएगी।
बस सर ललिता कुमारी वर्सेस स्टेट ऑफ यूपी में तो ये मैंडेट प्रोविजन दिया गया है ना कि एवरी पुलिस ऑफिसर इज
बिल्कुल ड्यूटी बाउंड टू रजिस्टर द एफआईआर इन केस ऑफ कॉग्निजेबल ऑफेंसेस, and if they are not doing this, it's a violation of the contempt of the Supreme Court.
Yes sir.
But बच्चे in practice जो ये प्रोसीजर है फॉलो नहीं हो रहा आज भी।
But sir, ये तो mainly true है ना, अगर if some police officer is not working as the this guidance, तो सर हम बोल सकते हैं like अगर किसी को पता है अगर ललिता कुमारी के केस के बारे में, तो अगर उनको याद नहीं है तो हम इस बिहाफ पे उनको याद तो दिला सकते हैं ना, like they are
बिल्कुल, आप अपनी कंप्लेंट के बाद भी कंप्लेंट उसको नंबर डाल के कंप्लेंट नहीं दे के बता सकते हैं। बच्चे वो बताने के बाद भी नहीं करते।
तो सर फिर फायदा क्या हुआ फिर जजमेंट का, जो इवन पुलिस ऑफिसर ही फॉलो नहीं कर रहे हैं।
जजमेंट सुप्रीम कोर्ट ने हम लोगों के लिए दी। अब फायदा तो ये है कि अगर मान लो विजिलेंट लोग है, कोई सुप्रीम कोर्ट जाएगा कि एक आपके ऑर्डर कंटेम्प्ट होगी, तो फायदा तो फिर आपको उस दिन पता चलेगा कि क्या है। जब सुप्रीम कोर्ट उनकी रेल बनाएगा कि भी आपने फॉलो नहीं किया, तो बच्चे वो तो अपना राइट एक्सरसाइज करने की बात है। राइट आपके पास बहुत है।
यस सर, वो तो बहुत ज्यादा, बस हमें पता नहीं है और कुछ एक्सरसाइज कर नहीं पाते इवन पता होने के बाद भी।
पता ना राइट, तो वही तो लॉ में कहते हैं ना, दोज हु आर स्लीपिंग ऑन देयर राइट्स, उनको कोई राइट देना ही नहीं है।
यस सर।
So, sir, after Sonia Sharma, I think Sonia Sharma, you are satisfied now.
मैम अभी क्वेश्चंस गेट आउट बाकी है, बट मे बी
We have a lack of time. I
Yes,
think
yes,
we are
yes,
running to the
okay.
time.
एफआईआर जो है, एफआईआर सबसे बड़ी बात इज नॉट एन एनसाइक्लोपीडिया ऑफ द इवेंट। ये कोई रिक्वायरमेंट नहीं है कि एफआईआर में ही सारे कंटेंट आ जाए। एफआईआर में उस टाइम की स्थिति क्या थी, विक्टिम की, अपना उनके डिसीज्ड के फैमिली मेंबर्स की, उसने 5 ही बातें बताई, फला फला आदमी ने फला टाइम पे मार दिया। उसके बाद पुलिस 161 की स्टेटमेंट नोट जब डाउनलोड करती है, उसमें वो बहुत कुछ ऐड कर सकती है। अगर मान लो एफआईआर में वो पूरे कंटेंट नहीं बता पाया कंप्लेनेंट, तो उसका ये मतलब नहीं है कि वो बाद में ऐड ऑन नहीं होंगे। इसीलिए इसको सुप्रीम कोर्ट ने एनसाइक्लोपीडिया नहीं बोला है।
तो सर ये साइक्लोपीडिया से रिलेटेड कोई केस है क्या?
बिल्कुल है।
हाँ जी सर।
सुप्रीम ऑफ पुलिस सीबीआई वर्सेस तपन कुमार सिंह।
ओके।
वर्सेस तपन कुमार सिंह 2003।
ओके सर।
इस केस में क्या हुआ कि सीबीआई डीएसपी को एक खबर मिली, बहुत पुराना टाइम का केस है 1990 का, कि एक व्यक्ति फलाना ऑफिसर 1 लाख रुपए रिश्वत के लेके एक गाड़ी से जा रहा है। तो उन्होंने अपनी रिपोर्ट डीआईजी को बताई। डीआईजी ने तुरंत टीम कॉन्स्टिट्यूट की। उन्होंने एक जीडी नंबर, जो बोलते हैं जनरल डायरी बोलते हैं पुलिस में, जिसको हम डीडीआर बोलते हैं, डेली डायरी रिपोर्ट। मान लो पुलिस हर चीज की एफआईआर दर्ज नहीं करती, पर डीडीआर कर लेती। जैसे आपने कंप्लेंट दी आज, तो उसी दिन पुलिस उसकी डीडीआर जरूर कर लेगी दर्ज की, आज ये कंप्लेंट आई है मेरे पास। तो उन्होंने अपनी जनरल डायरी रिपोर्ट में डाला कि ऐसे ऐसे रिपोर्ट मिली। उस बेसिस पे टीम वहां से निकली और उन्होंने उसको रोक लिया, पर्सनल ऑफिसर को, नागपुर में। और वहां चेकिंग के दौरान उसके लगेज से 1 लाख रुपए की रिकवरी हुई। पुलिस ने प्रिवेंशन ऑफ करप्शन एक्ट में पर्चा दर्ज करके, इन्वेस्टिगेशन करके, अरेस्ट करके उसके खिलाफ चार्जशीट दे दी। ट्रायल कोर्ट में जो एक्यूज था वो 482 में हाई कोर्ट में आ गया, क्वैशिंग ऑफ द एफआईआर। जब ये लिखा तो हाई कोर्ट ने बड़ा अच्छा लिखा, द हाई कोर्ट आफ्टर कंसिडरिंग द सबमिशन argued on behalf of the parties came to the conclusion that journal diary entry did not disclose the commission of a cognizable offense, and therefore investigation pursuant to such journal diary entry was illegal. The first information report which was lodged after investigation was conducted in part was also illegal, and consequently no case could be initiated on the basis of such an allegation. और हाई कोर्ट ने वो एफआईआर क्वैश कर दी। जो स्टेट गवर्नमेंट थी वो सुप्रीम कोर्ट चली गई, और सुप्रीम कोर्ट जाने में उन्होंने सिर्फ एक ही प्ली ली। One contention of the state council was that the information recorded in the GD entry does disclose the commission of that. Even if the contention that after recording the GD entry only a preliminary inquiry was made, it is not accepted. He is still entitled to sustain the legality of the investigation on the basis of the GD entry, may be treated as first information report, since it disclosed the commission of a cognizable offense. हाई कोर्ट ने ये डिसाइड किया कि जो ऑर्डर ऑफ द सुप्रीम कोर्ट ने डिसाइड किया, द ऑर्डर ऑफ द हाई कोर्ट इज एरर, और ये जो एफआईआर क्वैश की है वो गलत क्वैश की है, इसके खिलाफ ट्रायल चलेगा। जो डीडी एंट्री में एफआईआर इज नॉट इनसाइक्लोपीडिया, द इन्फॉर्मेंट मे लॉज अ रिपोर्ट दो ही मे नॉट नो द नेम ऑफ द विक्टिम ऑफ द एसएल। हाँ जी,
I think Sania, now you're satisfied, and I would like to give a chance to Srishti Devi. She raised her hand from a very long time. Srishti, Srishti.
Sorry, ma'am, it's by mistake.
Okay, no problem. So Ritu has dropped her query. She said if police deny for the FIR due to ex parte judgment and after that set aside application penguin in front of honorable court, so under section 156 clause 3 FIR can be registered.
पहले तो जब भी हम मान लो कंप्लेंट देते हैं पुलिस में, तो एक्स पार्टी की तो जरूरत ही नहीं है। एक्स पार्टी जो होता है वो सिविल प्रोसीजर में होगा, क्रिमिनल में कोई एक्स पार्टी नहीं। मैंने कहा कि एक्स ने मेरे साथ ये लड़ाई की, मेरे डंडे मारे वहाँ पे, तो मैंने कंप्लेंट दी। पुलिस की ड्यूटी बनती है कि वो उसकी एफआईआर दर्ज करे। उन्होंने एफआईआर दर्ज नहीं की। आप कोर्ट में जाएंगे, आप पहले सुपरिटेंडेंट पुलिस को मिलिए। ये जरूरी नहीं है आपको उसको मिलना ही है। आपने एप्लीकेशन ही सुपरिटेंडेंट पुलिस के नाम मार्क की तो इसका मतलब ये है कि आपने उनको मिल लिया। फिर भी आप मिलना चाहते हैं कि मेरी एफआईआर दर्ज नहीं हो रही, मिलिए, वो भी आपकी मदद नहीं करते। तो 156(3) में जब आप हाई कोर्ट के मजिस्ट्रेट के पास जाएंगे, इलाका मजिस्ट्रेट, जिस थाने का वो एरिया होगा उसका इलाका मजिस्ट्रेट वो ऑर्डर करेगा, ये देखते हुए कि कॉग्निजेबल ऑफेंस जो है ये बन रहा है, तो फिर उसके बाद वो ऑर्डर करके एसएचओ को उसमें एफआईआर रजिस्टर्ड करवाएगा। और इसमें बड़ा ट्विस्ट बताता हूँ आपको, बड़ा इंटरेस्टिंग पॉइंट बताता हूँ। अब पुलिस को क्या लगता है? पुलिस को लगता है कि एक एफआईआर मैंने दर्ज नहीं की, बट कोर्ट ने जज कर दी ऑर्डर से, और कोर्ट उसमें कैंसिलेशन लेके आ जाती है पुलिस कोर्ट में, और कोर्ट फिर अपनी ऑब्जर्वेशन देता है कि नहीं कैंसिलेशन नहीं बनता। फिर दोबारा वो कोर्ट उसको बोलता है कि भाई लेके आओ। थर्ड टाइम ना कोर्ट उसको ये नहीं कह सकता कि भाई नहीं, कोर्ट की ड्यूटी है या तो कैंसिलेशन को एक्सेप्ट कर ले या फिर अपने आप कॉग्निजेंस ले। आपने वो लड़की जो तलवार थी यूपी में मर्डर सुना है आप लोगों ने?
Yes, sir.
Yes,
उसमें क्या हुआ? बड़ा इंटरेस्टिंग केस है। सीबीआई ने पहली बार चार्जशीट लेके आई कि भी कोई एक्यूज मर्डर हुआ है, पर हमें किसी एक्यूज को, इसकी मदर, फादर और लोगों के खिलाफ हमें सबूत नहीं है। कोर्ट ने वापस री इन्वेस्टिगेशन के लिए भेज दिया, रिमांड दे के दोबारा इसकी फर्दर इन्वेस्टिगेशन करवाओ। अब वर्ड पे ध्यान देना, मैं री इन्वेस्टिगेशन वर्ड यूज नहीं कर रहा, मैं फर्दर इन्वेस्टिगेशन वर्ड यूज कर रहा हूँ। कोर्ट ने कहा कि फर्दर इन्वेस्टिगेशन आप इसकी करो। सीबीआई ने फिर उसकी फर्दर इन्वेस्टिगेशन की, और 3 महीने के बाद फिर चार्जशीट लेके आई क्लोजर रिपोर्ट। क्लोजर रिपोर्ट मतलब कैंसिलेशन रिपोर्ट, कि भाई ये एफआईआर कैंसिल कर दीजिए, क्लोज कर दीजिए, क्योंकि इसमें हमें कोई भी एक्यूज नहीं मिला जिसने मर्डर किया। कोर्ट एज पर लॉ 190C CRPC 190C CRPC, court is duty bound to accept the cancellation report or to frame a charges against the accused if court deemed fit that the फला जिनके पुलिस इन्वेस्टिगेशन में, ट्रायल में उनके खिलाफ सबूत नहीं लेके आ पा रही इन्वेस्टिगेशन में, तो कोर्ट वहां चार्ज फ्रेम कर लेगा। थर्ड टाइम वो वापस नहीं करेगा, सेटल्ड लो है, वो 2 ही बार वापस कर सकता है। सेकंड टाइम वो वापस ना करके उसके खिलाफ चार्जेस फ्रेम करके ट्रायल चलाएगा या उसकी रिपोर्ट मान ले पुलिस की। उन्होंने फिर आरुषि मर्डर केस में पुलिस सीबीआई की जो दलील थी उसको डिनाई कर दिया और उनके खिलाफ चार्ज फ्रेम किया, और उसके बाद आपको कहानी पता ही, उनको कन्विक्ट किया फिर, और हाई कोर्ट ने उनको बरी किया। नाउ मैटर इज पेंडिंग बिफोर द ऑनरेबल सुप्रीम।
I believe we almost over with our time, because our next moderator of the next session is also.
So I have one more question. Sorry.
Ritu, yes, you may, but I can say that please, it will be the last
Really?
question. And somewhere I really enjoyed this session, but our participants' queries is just indicating that this session is really successful. So Ritu, again, I'm saying that because of the time, this will be the last question. Yes, please, Ritu.
Actually, sir, my question is that during the investigation, if IO give the bias investigation report and during the कोर्ट इन्वेस्टिगेशन अगर ये चीज पता चल जाती है कि आयो ने बायस जो कि इन्वेस्टिगेशन रिपोर्ट बनाई है तो क्या आयो के अगेंस्ट चालान मतलब चार्जेस लग सकते हैं सर?
हाँ जी, बिल्कुल लग सकते हैं। आप एक ना जनरल टर्म में हम उसको बोलते हैं इस्तगासा।
सॉरी सर,
एक जैसे कंप्लेंट जो है ना, कंप्लेंट को हम उर्दू में बोलते हैं इस्तगासा।
ओके,
आप कोर्ट में उसके खिलाफ कंप्लेंट डालिए, इस्तगासा डालिए, इस इन्वेस्टिगेशन ऑफिसर को मैंने ये एविडेंस दिए थे और इसने ये जो इन्वेस्टिगेशन पे ना तो इन्वेस्टिगेशन की और ना ही ये जो एविडेंस मैंने इनको सरेंडर किए थे इन्होंने पार्ट ऑफ फाइल बनाया, तो आप वो डालिए उनके खिलाफ, कोर्ट में एक्शन होगा। अगर आप प्रूव कर पाएंगे इसकी गिल्टी तो उसके खिलाफ डिपार्टमेंटल भी होगा, डिमोशन भी हो सकता है, सस्पेंड भी हो सकता है।
ओके, थैंक यू सो मच सर, थैंक यू।
So there is another last query by the Krishna Sai. Sir, in instance of criminal trespass, the case takes shape of the title disputed by the offender. For example, petitioner themselves. Then how can the defendant seek for remedy against the offender or petitioner? Krishna, if you are present in this session.
Pardon, please, ma'am, दोबारा बोलेंगे एक बार?
I read it again, sir. In instance of criminal trespass, the case takes shape of title dispute by the offender. For example, petitioner themselves.
Okay, I understand. ऐसा है कि मैं समझ गया कि आप चाह रहे हैं कि एक प्रॉपर्टी में मेरा हक नहीं है, मैंने क्रिमिनल ट्रेसपास किया, आपका हक है और मैंने आपके खिलाफ एक क्रिमिनल ट्रेसपास की एप्लीकेशन दे दी। दोनों बहुत ही सेपरेट वो हैं। मेरा एक चीज पे राइट है, मेरा हक है, तो मेरी ड्यूटी बनती है कि मैं उस एरिया के एसडीएम को, उस एरिया के एसएचओ को लिख के दूं पहले कि मेरा ये घर है, इसमें ये मेरा राइट है, ग्राउंड फ्लोर मेरा है, फर्स्ट फ्लोर मेरा है, मैंने वहाँ पे आज प्रोसीड करना है और मुझे ये डर है कि जो ग्राउंड फ्लोर वाले हैं, फर्स्ट फ्लोर वाले हैं, मुझे रिस्ट्रेन करेंगे मेरे राइट से। इन दैट केस क्रिमिनल ट्रेसपास केस नहीं बनेगा। अगर आप वहाँ सीधे ही जाके हमला करेंगे या फिर अपना राइट एक्सरसाइज करेंगे, इन दैट केस डेफिनेटली वो जो व्यक्ति है जो आपका राइट रोक रहा है वो आपके खिलाफ मूव करेगा एप्लीकेशन और उस पर पुलिस को एक्शन लेना पड़ेगा। इसलिए आपको पता होना चाहिए कि भी हमें अपना राइट एक्सरसाइज करने से पहले हमने क्या फॉर्मेलिटीज पूरी करनी है। हम उसके पहुंचने से पहले हम रिंग द बेल, हम पहले पहुंच जाए अथॉरिटीज के पास, पब्लिक अथॉरिटीज के पास, और हम अपना राइट बताएंगे, हमारा राइट इस व्यक्ति ने ऐसे ऐसे कहा।
So it is a formal time to say thank you to our
आप लोगों को अच्छा लगा होगा। मैं बड़ा नर्वस था देते हुए इतने इंटेलिजेंट आदमियों को कैसे मैं कुछ बता पाऊंगा। मैं सोच रहा था ये बात।
It is really wonderful because the session is giving feedback through its own, and we need not to ask in any through any form, because our students, they interact so well, and I think they recall every section of the CRPC through this session.
I'm really thankful to you, ma'am, personally, and the chairman, ma'am, and the coordinator, and all the team.
Right,
I'm really thankful.
Right,
Sir, thank you so much. And thank you is very small word, because your actual contribution is from the field, which I think we people are not able to share with our students. So please don't make us feel embarrassed by calling us the intellectuals, because you are the eminent and expert of your own field. And we are hearty thankful to you, sir, for coming this platform and sharing your experiences and vast knowledge with our students. Thank you so much.
Thank you, ma'am.
so feedback is also in the comment boxes, So you can see that the students are mentioning amazing session. So again, thank you.
एक बार कभी ओपन
Thank you
होगा
for
तो
coming.
पर्सनल वहाँ पे देंगे ना, उसको और भी फर्क पड़ता है अभी.
Okay, sir. Sure, sir.
Definitely.
We will call
Sir,
you.
it's a request that please stay with us in the valedictory session. If you could spare half an hour extra.
Okay, ma'am.
Professor Shirijit, I think he has joined us, and Madam Vice Chancellor is likely to join soon.
Yes, I'm with you.
Yes.
Thank you, sir.
Good afternoon to all of you.
Good afternoon, ma'am.
Fine. Professor Shirijit is also here. Sohan sir, we are very thankful for the heated discussion which students enjoyed a lot. Like comment boxes flooding with all kind of appreciation. Hats off to the efforts and the spirit with which you took all the questions. Although I'm not from law background, but still I enjoyed each and every fact and the things which had been discussed out here. Thank you, sir. Thank you very much.
Thanks, ma'am. Thanks to you.
We are about to start with our valedictory session. All are requested to keep the camera on. Good afternoon, ma'am.
Good afternoon.
Honorable Vice Chancellor, ma'am, has joined us. It's our proud privilege to have you here, ma'am. Lovely to see you. Ma'am, with your due permission, can we start with the proceedings?
Yes, Dr. Suman, you can please.
A very good afternoon to all dignitaries, eminent guests, intellectual aspirants, and my dear colleagues. With great exultation, I take this opportunity to extend warm wishes and hearty welcome to all present here. To start with valedictory session, I hereby invite in charge, Department of Laws, the Program Director, Dr. Rajesh Hooda, to welcome our guests and present the program report. Being coordinator, I should confess before the audience that she is the brain behind this event. She is the reservoir of energy who believes in putting heart and soul in each task. Ma'am, please, over to you.
Thank you so much, Dr. Suman, for the good words for me. Good afternoon, everyone. Warm and kind greetings to one and all present here. I very cordially welcome you all in the 2 days National Moot Court Training Program, and the valedictory session is going on. I would like to extend my heartfelt wishes and thanks to all the present in the meeting. Moot court is an important activity of all legal institutions, for law students, for a lawyer, for any aspirants who is going to make a career in the law field. We experienced and observed that some students want to do fairly in their student life, and it really pays. Moot court competition is one such part and practice wherein ambitious and honest learners get to know, get to hone, and get to acquaint themselves with the advocacy skills, researching, and also the analytical skills. This enables them to establish and promise a good career in the field of law. Keeping in view the need of the students to prepare well in time, Department of Laws took this initiative to organize this training program. Every second, every moment in the life, हम कुछ सीखते हैं. Classroom teaching is also a training. But this moot training is not a part of usual classroom teaching. It is, in fact, students' domains who want to do something extra. It's a small step to help the students by introducing, and we can say by intruding in their space. We received very overwhelming response from all sides, either the resource persons of the technical sessions, our participants registration it is, which crossed 400, figure 400, and the participation we received is from across the nation, from various institutions within the state and out of the state also. The figure clearly reflects the high demand for moot court training and more such events. Moot court competitions are held by the institutions very frequently, but formal training is generally missing. Though BCI prescribe for moot court participations, but mooters generally prepare without having any proper idea, knowledge of basic framework to prepare memorials and forwarding arguments. This we intended to impart to our law students. The first technical session was a demonstrative round wherein one student from Jindal Global Law University, Mr. Kotile from first year, presented the case on a given constitutional moot problem, and two other students, Miss Geeta and Miss Bhavna, pleaded from BPS side. I am proud to share that Department of Law is a legend to plan such a training activity. The resource persons of the technical sessions happily announced and congratulated the team, its organizing team for this event. In fact, the organizing committee initially was very apprehensive on the point whether it will be feasible or appropriate to organize a training program on the moot. We had never heard before any such training in the moot aspects, but only the moot court competitions we were hearing and observing all around. But it has been really a wonderful experience. Participants have been very interactive during the sessions, and they had lot of queries and got to know the standards and procedural guidelines for preparing and researching moot court, either that is constitutional, criminal, or the civil. It is a pleasure to announce that the event has been very meaningful and motivational to the students and faculty as well. In the valedictory session, I would like to welcome and introduce all the participants to our guest and Honorable Vice Chancellor Madam. Today, we have Professor Sudesh, our Honorable Vice Chancellor, for presidential address among us. She is an acclaimed academician and a researcher. She is a wonderful administrator also as the faculty and all the employees of the BPS University could see the things moving in a very positive manner and in a very short span, because she has not spent a long time with us. She joined very recently, but she has given through her research, through her contributions, through her commands, a message that she believes in action. She is a woman of substance, and she loved and liked the work culture. And definitely, we are sure that very soon our university will attain greater heights under her guidance and patronage. Welcome you, ma'am. We are very grateful, ma'am, for your benign presence and motivation, for sparing your valuable time with us. As our chief guest, we have Professor S.G. Shrijit, Executive Dean from Global Jindal Law University. He is an eminent academician and researcher. His publications work is commendable and inspiring for all the faculty and the researchers, and all his publications has found a place in and listed in Scopus journals. Welcome you, sir, and thank you for joining us. It is a great pleasure to have all the eminent personality, Madam Vice Chancellor and Professor Shirijit ji with us, and we are going to get to hear them. Another legal expert, Advocate Anita Balyanji, is with us as our guest of honor. It would be a pleasure for all of us to listen to her experiences and inputs on a real court practices. Welcome you, ma'am, and thanks for coming on a very short notice.
Thank you, Dr. Rajesh. Thank you.
Thank you, ma'am. I welcome all other dignitaries, our Dean Professor Nehraji, all other in charges and colleagues from BPS University and outside. And I extend my warm wishes and cordial welcome to one and all present here. Thank you all for making this event meaningful and gracing the occasion by your benign presence. With whose thanks and wishes to all of you, I take leave and welcome you all once again. Thank you. Over to you, Dr. Suman.
Thank you, ma'am. Thank you very much. Now it's time to introduce the guest of honor of valedictory session, Advocate Anita Balyan. Ma'am has been practicing as an advocate at Punjab and Haryana High Court, Chandigarh since 2003, with an expertise in handling cases of litigation pertaining to land acquisition, service matters, constitutional, family, and criminal matters. Since 2015, she has represented the Union of India as Senior Panel Counsel. Ma'am is an active member of Advisory Committee of Dr. B.R. Ambedkar National Law University, Sonipat. She is also a member of Sexual Harassment Committee of UHBVN, Haryana Electricity Regulatory Commission, and Advocate General Office of Haryana. Ma'am acts as a committed member of Committee of Lady Advocates for giving free legal services to poor women of Tri-City. Ma'am, audiences are very excited to hear from you. Without taking much time, I hereby invite the guest of honor, Advocate Anita Balyan. Over to you, ma'am.
Thank you, Dr. Suman, for your kind words. Good afternoon to all. Honorable the Vice Chancellor, Professor Sudesh, the Chief Guest, Dr. Shrijit, and all the learned members of the law faculty. Although, as I joined in the morning session, I realized almost every aspect has been covered by the speakers, earlier speakers, very wonderfully. But still, I'll take up few points related to traditional litigation. I'll put my focus on traditional lawyering, as I'm a practicing lawyer. So I begin. Dear students, what we read in law colleges is different from what we practice in courtrooms, because theory is different from practice. As we all know, we have hierarchy of courts. We have taluka courts, tehsil courts, we have trial courts, high courts, and the Supreme Court. Each court has its own demand, different nature of work, nature of practice, different nature of litigation. A trial court lawyer is an architect of the litigation. He drafts a case which reaches up to Supreme Court. If we are slightly careless or casual in our drafting, we might lose a very good case. This aspect needs to be kept in mind. And one thing which I would like to address, and which is very close to my heart, is that these days, may not be earlier, but these days what we find is the younger generation who's joining this profession, they somewhat take pride in joining the High Court or Supreme Court directly. they somewhat, take it as demeaning that if somebody asks them to join a trial court practice. Please let me tell you, clear this myth in your mind. Unless you are a good trial court lawyer, you cannot be a excelling advocate in the profession. Unless you have a grip over the knowledge, unless you have a deep insight, you cannot excel. Yes, you may be an advocate, but I am talking of the legal luminaries who have excelled in this field. They started their practice from the trial court. So I would put across my suggestion to all the budding lawyers or to all the aspiring lawyers who wish to join the traditional litigation, that you must have an experience of a trial court. Yes, you can join the high court later on, but you must take an experience of the trial court. Likewise, high court has its own demand, has its own nature of work. High court has its original jurisdiction in the writ area, which trial court do not possess. It is an area where High Court is possessed with vast powers under Article 226, you must be aware. It can issue any orders, directions, or grant any other relief which it deems appropriate to meet the ends of justice. Likewise, Supreme Court. Now, apart from this, I would touch another aspect, and that is the courtroom decorum. First and foremost, I am not at all saying that the younger generation is not dressed up properly. I would touch this aspect because what we observe in these days in courtrooms is dressed up in a very funky manner, or you can say in a very trendy manner. Students, please take a note of it. If we have a dress code which is prescribed under the Advocates Act, then we must stick to that. I don't say that you will be snubbed by someone. Yes, you may be. You never know. Somebody who doesn't like your dressing up, you might get a snub. But why to invite that situation? Because how you dress up speaks a lot about you. And you are, mind you, you are in a profession where you are accountable, where you take up the responsibility of giving relief to someone. So your personality, your demeanor should reflect that. Thirdly, the courtroom, ethos of the courtroom. How a lawyer enters and how a lawyer exits the courtroom gets observed. We should be very humble. We should be assertive but not aggressive while we are presenting our case. We should be very respectable to the court. We should be very respectable to the opposite counsel. You may lose a case or win a case. There are very many factors involved in it. But foremost, you should be humble, you should be soft, and you should be very well prepared. Lastly, I would say various qualities or traits of a good lawyer. There is no substitute, mark my words, there is no substitute for hard work. You cannot do well in this profession unless you are an avid reader, you are jack of all trades. You should be reading literature, you should be reading philosophy, you should be reading psychology, you should be reading newspapers, you should know what is happening around you. Unless you are updated, you don't survive for long in this profession. So with all this, I don't intend to take much time because you people have been really you've been really hearing the earlier learned speakers, and I have been given a limit to speak. So I'll take a leave, and before I take leave, I extend my heartfelt gratitude to the Honorable Vice Chancellor, the learned members of the faculty of the law department who undertook this massive moot court activity in these COVID times. It is really commendable. my good wishes to you all and to all the students, that work hard and there's nothing that can stop you. It is your own mindset, it is your own limitations. Break free, set free, work hard and get going. Thank you so much. Thank you.
Thank you, ma'am. Thank you very much. Discipline is the backbone of every career, rightly said by you, and I hope students will try to imbue your advice there in future. Thank you. Thank you very much, ma'am. Now I take an opportunity to introduce the chief guest, Professor and Executive Dean of Jindal Global Law School, OP Jindal University, Sonipat. Sir is an alumnus of JNU and completed LLD in International Law and Legal Studies from University of Lapland. Being a defining contributor in the field of law, many Scopus indexed research papers come to his credit with the titles like Law and Regulations on Legal Education in India before, during, and after COVID-19, with post-COVID-19 manifesto, many shades of temporal pluralities, alternative ethics of law and society, and the rise and fall of astronauts in international space law, etc. Sir has also contributed a chapter in the book named Gandhi and International Law, Satyagraha as Universal Justice. Sir, you are a maestro in the field of law. Here I invite the chief guest of the session to enlighten our audiences. Over to you, sir, please.
Thank you very much, Dr. Suman. Thank you very much. Honorable Vice Chancellor Sudesh Chitkara, Chief Guest Advocate Anita Balyan, distinguished faculty members, resource persons, and my dearest students. It's truly an honor to be invited to this event. Since this was an event on a moot court which provided students with essential training to participate in the moot court, let me spend the limited time given to me to reflect upon the very idea of a moot court. I would focus on three P's: pedagogy, practice, and pride. So that means I'll be focusing on whether to what extent moot court acts as a pedagogy, to what extent moot courts serve practice, and to what extent the pride associated with competition serve in academic excellence. So the three P's of the moot courts. Number one, let me focus on the pedagogic part of it. We all understand that even though the history of moot court can be traced back to the days of Cicero, we understand that the modern origins really was in American law schools in the 1870s, when the Socratic method was looking forward to, or American professors were looking forward to institutionalize the Socratic method. Well, while the Socratic method took the students from the factual surface to the doctrinal core, Socratic method never provided any context. And most of the time, it's just a dialogue between the professor and the student, where you know that there's a clear hierarchy in the communication, because professor all the time keeps on refuting the student's argument until the student reaches a no answer point. But we all know that no answer point of the student is actually the doctrinal core from where the entire dispute has arisen, or the entire dispute arose. They decided to shift the context to a two-way route. That means that you literally shall have a dialogue to feel actually what a legal dispute means. So, American law schools institutionalized the Socratic method in the form of the moot courts. I'm only talking about the modern origins. But still, it would take a century for the moot courts actually to become popular in the rest of the world. Moot court traveled from United States to Scandinavia, to Europe, to Asia, and even to Oceania with necessary customization. Now, is moot court, to what extent moot court can be used as a pedagogy, or is not, or how have we not underplayed the academic or the pedagogic utility of a moot court or not? How many professors would be willing actually to use moot court as a method of assessment in their classrooms? Well, while we do have mandatory moot courts because regulatory bodies require us to have moot courts in the universities, how many professors would be willing to have moot courts in their rooms or moot courts in their classrooms? Now, of course, there are professors who literally use it, who dare to use it, or who rather constructively use it. But of course, is then mooting simply something that is meant to develop your argumentative skills? Well, perhaps this this is not a correct proposition because this reminds me of a famous sardonic verse by Lewis Carroll in Alice in Wonderland. Quote, in my youth, I took to law and argued each case with my wife. The muscular strength it gave to my jaws has lasted the rest of my life. Now, there is a myth here that mooting is all about gaining muscular strength to your jaws. Mooting is all about oratory. Mooting is all about rhetoric. It's all about discourse. Well, this probably is an underestimation of the true potential of the moot court. Because when we do moot, we know that we learn the art of ratiocination. We learn the art of discovery. We learn logic, including syllogisms. We learn constructions. We get familiarized with unique semantics. Most importantly, in moot court, we learn the art of making discourse, especially discursive constructions. So calling moot a skill in oratory or an exercise in presenting a case, that's a little bit underestimation because moot brings with it the holistic development of a student. Whatever Socratic method can provide, mooting can also provide. If examination is an assessment, so can moot be an assessment. However, we all understand that there are some myths also surrounding the moot, or there are some wrong ideas also surrounding the moot. It is that moot is a real court. Well, at least the academics should play the role of enlightening the students that, well, moot court is a meta court. It's a meta world. It's not a real court. At the best, moot can be an appellate court. As Advocate Anita Balyan mentioned, that the true ambience of a trial, which a lawyer needs to internalize before they could practice the law, the moot courts cannot provide. Moot courts cannot capture the emotional response of a lawyer in the courtroom to the questions of the judge. Moot court cannot capture the sentiment of a client, which the lawyer is supposed to represent. Now, this is a problematic concern, or this is a problematic proposition, because there is a total absence of the client's narrative in the moot court. We all know that when academics draft the moot court problem, they draft it with a conscious neutrality to their narrative. Parties are supposed to work from the petitioner's side and also from the respondent's side. While working on the petitioner's side, the student is conscious that I need to prepare arguments from the respondent's side also. So the persuasiveness which they could bring to the cause of their client literally is absent in the moot court. So this is what I mentioned, that moot court creates a meta reality. Now, of course, it's impossible for the law schools to reproduce what happens in a court, including the temperature of the court, including the emotions which are played out in the court. It's really hard because there is a cause of a client, there is a client there is a party on the other side, whereby you will always witness conflicting causes and conflicting emotions. We understand that, or we academics need to understand that this cannot be reproduced in a classroom in the form of a moot court. So it's the law school's responsibility to inform the students that moot court has a larger pedagogic value, but moot court is not exactly a reproduction of what exactly transpires in a court. So the limitations of this moot could go to the students, not as a negative narrative, but as a positive narrative, that moot court has a larger pedagogic utility, but limited when it comes to practice. I remember to have read a brilliant article by an American law professor in a Journal of Legal Education with the title, Too Much of Moot and Too Less of Court. That's what transpires in a moot court, that you literally give the students the understanding that, well, you are reproducing the court in the classroom and the actual court differs substantially. I've conversations with my colleagues in the litigation, and I've asked them actually how much of practice or how much of practicality you can literally find in the moot court. Well, they said that indeed the theory which students learn in the class is contextualized in the moot court. So in that sense, they literally learn the art of applying facts to the law. But when it comes to experiencing the real courtroom, what we could call the phenomenology of a courtroom, that is yet to come to the moot court. But then there is always a defense for the law school. That law school has a modular approach to training the students. Moot court is not a Christmas tree on which you can hang every Christmas. We have moot courts, we have trial advocacy, we have client counseling, we have alternative dispute resolution clinics, we have community clinics. It is through these different modules that law school holistically develops the students ready to go to the profession. So we need not see moot court as a Christmas tree, as I've mentioned, on which you can hang every good cause. So the criticism that trial element is absent from the moot court, well, that probably can be defended by saying that we do have trial advocacy society and we do have trial advocacy competitions. How about the lawyer-client relationship? Well, we try to reproduce and recreate that relationship through the client counseling competitions, through the client counseling sessions. So the clinical engagement which the law school provides to a large extent psychologically prepares the student to go and start practice in the court. But then, of course, there is a lot to learn from the court. Now, even when we impart moot court as a pedagogy, it is my strong sense that there's a larger need for collaboration between academia and the profession. Let there be dual teaching there. While the practicing advocate will teach the students the art of practicing, or the art of the practice of the moot, the law professor will have to explain the theory of the practice. This will give a better internalization to the student. This will be a combined teaching. While the practitioner will teach the students the art of mooting, the art of advocacy, the teacher could explain actually the logic and the syllogisms and the theory of this practice. Now, of late, there has been a new trend that mooting has been taken to another level, the level of competitions. We began to see this trend in India mainly in the 90s. And we have now many prestigious and distinguished moot courts like Jessup, Manfred Lachs, William Seabass, Henry Dunant, Stetson, and definitely, winning the title is a matter of a prestige. There is also a feeling that if I do well in Stetson, well, I belong to an elite class. If I do a national moot court competition, well, probably I belong to a class which is lesser than that of the international mooter. Well, this kind of a sense of class is reinforced in the minds of the students due to the madness of the competitions around us. But I'm not making a case here against the moot court competitions. It's a fact that there is a certain pride associated with that. But while students participated in the moot court competition, they should also understand that beyond all this pride, there is also a learning. There is a broadening learning which happens through every moot court. So the winner is actually the best learner. And if you didn't win the title, well, your learning continues and you need to learn better. So winning in a moot is as good as passing in an examination and nothing beyond that. So law schools need to reinforce this pedagogic value of the moot court rather than pushing students in the madness of it. But indeed, winning titles adds confidence to them. It definitely ornates their CV. It may have a value, but beyond all that, students should transcend actually the parochialism of winning. There should be a competitive spirit. There should be a winning spirit. But beyond that, let not the madness of the competitions take students in. I myself was a mooter during my school days. I represented India in Manfred Lachs moot some 2 decades back, and having lost to National University of Singapore, it substantially affected my confidence. And from that, then onwards, I began to have a rethink that is winning the real test of one's skills or not. Now, the final thing that, we live in a world which philosophers brand as postmodern, or rather we live in a world where, something has transformed. That means it could be post-war, it could be postmodern, it could be post-pandemic. There is something post. That means we have transcended something to come to the new world. In this world, there are 2 voices. There is voices of the orthodoxy and there are voices of the heterodoxy. Now, there is a question here. Can moot court listen to the voice of the heterodoxy? Well, I understand I'm speaking in a Mahila Vishwavidyalaya and I'm conscious of this fact, and hence I'm making this proposition. How much can moot courts accommodate the concerns of feminist scholars? How can a mooting incorporate or a judge, to what extent a judging would be sympathetic to the lived experience of a woman if it is narrated as a doctrinal position in the moot court? When you look at the very design of the moot court, it is deeply orthodox. It is deeply formalistic. It is deeply positivistic, that you run the risk of reproducing hierarchies, you run the risk of reproducing class, you run the risk of reproducing all kinds of conventionalities. Now, what if I argue from a critical legal theory perspective before the judge? What if I argue from a postmodern heterodox perspective? What if I narrate lived experience of a woman? What if I narrate the lived experience of somebody who's of a neutral gender? Whether moot court has a sentiment for that. So probably that there is something, in this post, we also need to largely reimagine the very form and substance of the moot court. We constrain students by giving them 20 minutes, 30 minutes, and then there is a preset pattern, response, rebuttals. But we need to think beyond that what space, the question is actually largely to the professionals, that is courtroom a space where one has room for critique? If courtrooms have room for critique, definitely moot courts shall also have room for critique. Now, I would say here, I would end by saying that probably, it is time that we need to go beyond this obsession with international moot courts, constitutional law moot courts. We actually should bring moot courts which literally we shall have problems in the moot courts which literally reflect the true life, the abject conditions of the people here. We need to have moot courts which capture poverty and a petition before the court on that. We need to have moot courts which capture the social movements. We need to have moot courts which has the subject matter, the conditions of women and children in the society. Such moots probably will help the judges and also the practitioners internalize the reality of our society. So I'm just submitting a case for the larger reimagination of the moot court. So with that, I wish a good luck to all the students who participated in this. It's a commendable endeavor by BPS Mahila Vishwavidyalaya that you have decided to give preliminary training to the students. But my request would be that if you add a little bit of thought also to these endeavors, your students will emerge as the best mooters, the best students, and that will give them a broadening learning experience. Thank you very much. Thank you for this opportunity.
Thank you, sir. Thank you very much. The benign presence of Honorable Vice Chancellor, Ma'am, Professor Sudesh, the patron-in-chief, is a matter of pride for all. BPSMV fraternity is fortunate to have such visionary as a head of this huge family. Ma'am, your excellence hardly needs an introduction. It would be like showing candlelight to the sun. I feel privileged to introduce our Honorable Vice Chancellor, Ma'am, to elite audience. Ma'am's 31 years of experience depicts her versatility as an academician, administrator, and researcher. Ma'am had been the professor of University School of Management, Kurukshetra University, Kurukshetra, and she had also been director of Women's Study Research Center and HRDC Kurukshetra University, Kurukshetra. Ma'am had been awarded with Commonwealth Fellowship and postdoctoral fellowship. Other than giving remarkable contributions in the field of research, Ma'am had been a member of editorial board of various research journals and also organized international and national seminars. Ma'am's international exposure includes Oxford, Cambridge, Warwick Universities, London School of Economics, and University of Sydney, Australia. Ma'am is a member of Expert Committee of UGC AICT for Assessment, Accreditation, and Administration of Grants and Aid of Educational Institutions. She is a member of Associations of Commonwealth Scholars and Fellow, New Delhi. She had also remained actively involved in UGC program in capacity building of women managers in higher education. Ma'am, you are a person with distinct vision, an idol of knowledge, experience, and inspiration. Now I can feel the excitement and eagerness amongst the audience to hear words of wisdom from you. May I humbly request Honorable Vice Chancellor, Ma'am, for presidential address. Ma'am, please.
Good evening to everybody. It's my pleasure to be a part of this valedictory ceremony of 2 days moot court competition being organized by the Department of Laws, BPS Mahila Vishwavidyalaya. First of all, Dr. Srijit, Executive Dean of the Global Jindal University, young advocate Anita Balyan, who is a keynote speaker in this session, Professor Nehra, Dean of the Faculty of Laws, Dr. Rajesh Hudda and her young team who has been organizing this moot court competition for last 2 days online. They've done a commendable job by including so many people into this competition. It must have been a really, really very good learning experience for a large number of students. I must congratulate the team at law school for taking up this initiative, executing it so well. 400 students participating into an online event, and I'm pleased to see in the valedictory session also more than 130 people are present. That speaks about their efforts and the way they've been able to engage the people. And I was also going through the kind of experts they've involved in this program. That too is commendable. Your main speaker in the valedictory session, Dr. Srijit, who comes from Global Jindal School, which is a school which admits elite class, and the kind of training they give is entirely different. Even he might have observed here that these girls who are teaching here and the women law colleges, they're very rare. They're not too many. It's only both boys and girls study in law college, which is a unique in its own self. And I really feel because I'm a new entrant in this university. I had my own notion of how the university would be like, but the kind of organization skills they've exhibited have motivated me, and I'm sure the team at the law school at Mahila Vishwavidyalaya would be supported by young advocates like Anita. We would like to see you more with these faculty members, students, to give them the real feel of whatever is happening in the world. And when we look at legal area, lawyers, advocates, it looks like as if it is a domain for men. Very rightly pointed by Shriji. Legal is predominantly dominated by men. And the last 5 to 10 years, girls have been seen in the courtrooms. The number is increasing, but still what I feel is it's all a men's space. District courts where when I go, I hardly see, the space is predominantly a men's space. But the kind of efforts that is being made here, in times to come in, we'll have more legal experts in form of women. And not only that, when we look at the panels which are being, prepared by the educational institutions or other institutions, all men, maybe because they network more, because I feel that legal field is predominantly still dominated by men. So I'm encouraged to see the efforts being put up here, that in times to come in, it will be more inclusive, more women will come at all places, be it your district courts, high courts, panels, and everywhere. Also would like to appreciate the kind of resource persons that you have roping here. This will give our girls a better exposure, because I know most of these girls, they're coming from small villages, but they have great potential. So as an head of the institution, I only promise to the faculty here that I will leave no stone unturned in providing you all kind of assistance in terms of good resource persons. Even if the new education policies is emphasizing on new pedagogy of teaching all kinds of subjects. Like when we are practicing teaching law, it has to be associated with real practice. Some sort of combinations could be there, and we have young women practicing lawyers who could always come and teach once in a week, or they could do it on online also. Thanks to adoption of technology during COVID, it has done so bad, but one thing, we can have access to the best in the country for reaching, for which would have not been possible otherwise. And you've done it so well. Even digital जो platforms का better use करते हुए आप हमारे जो students हैं उनको एक नया मौका मिलेगा, मुझे ऐसा लगता है. And it's going to go a long way in mainstreaming the legal education for girls. And I've been here for almost 15 days. I feel really confident that it has great potential. The kind of events these, the various departments are doing, they have given me a lot of encouragement that there is a great potential here. The faculty is highly motivated, and they are going to take the Mahila Vishwavidyalaya to greater heights. Because I think the foundation stone is Mahila Vishwavidyalaya की lay down की गई है, that has been done by great saint. The time has come up to see its outcome. Its outcome, and all of you are going to contribute your bit in taking it ahead. And I don't know how often you are taking your students to the other institutions like Global Jindal is very nearby. And our students have a different kind of strength. That is their passion to move ahead. If we take these girls to good institutions which have good infrastructure, good faculty, good international exposure, I think these girls can do wonders. One thing which the big institution do not have is that is the passion to move ahead. That is very much required. So since I'm not a legal expert, a lot of new things I've learned during my listening to the various experts here, I just would like to say that you have to take it ahead and you have to include the skill component. Keeping in view the new education policy, you have to seek for various kinds of collaborations which could make this legal learning more interesting. And as an head of the institution, I promise all kinds of support to the law school. You can plan anything with Global Jindal, with the advocates in High Court, and all these kinds of things. So with these words, I thank the people, those who contributed, all the resource persons for, say, sparing their valuable time for these young girls and young participants at my institution. So with these words, I thank everybody who has contributed in making this happen and make it a successful event. So thanks to all.
Thank you, ma'am. Thanks for your blessings and guidance. We will try our best to meet the expectations and follow the advices given by you. Thank you. Thank you very much. Now it's time to thank formally all our guests and trainees present out here. I would like to invite one of our senior faculty members from the Department of Laws, Dr. Seema Daya, for vote of thanks. Over to you, Seema ma'am.
Thank you so much, Dr. Suman. A very good afternoon to each and everyone present here. I take the opportunity to give vote of thanks by Dr. Seema Daya from Department of Laws, Dagat Phul Singh Mahila Vishwavidyalaya. Extend my heartiest gratitude to our revered Honorable Vice Chancellor, Madam, and for gracing the occasion and for your really valuable enlightening words, motivational words for us, ma'am. Thank you so much, ma'am. I also extend my heartfelt gratitude to our guest of honor, Advocate Anita Balyanji, Advocate Punjab and Haryana High Court, Chandigarh, our Chief Guest of the program, Professor S.G. Srijit Singh, Executive Dean, Jindal Global Law School, Sonipat, for their benign presence, sparing their valuable time, and sharing your experiences here, sir. Thank you so much, sir. I'm also thankful to our speakers of the technical sessions for today's, Advocate Shubham Mishra ji, Advocate Vaibhav Singh ji, Dr. Sohan Singh, DA Panchkula, for joining the program and guiding our students on minute techniques of the mooting art. I'm also thankful to all deans, heads of the departments, faculty members for joining the program. Last but not the least, our dear participants who have patiently given the hearing, and they had really lots of queries here. And it was really very interesting and wonderful session for the students. Thank you for the thanks to all the organizing committee members for such a wonderful program for our students. And I hope and assure that this workshop will be very beneficial for our budding lawyers. Not taking much time, I again thanks to all of you. Thank you so much.
Thank you, ma'am.
Thank you, everyone. Thank you, Siva.
Thank you, ma'am.
Thank you,
Thank
dear
you, ma'am.
colleagues, for
Thank you.
joining this session. And my special thanks to the organizing team, Madam Anu, Dheeraj, Sandhya, Suman, because not a single second I could saw him off screen. The all time since yesterday inaugural session, they stayed in the meeting, boosted the participants by their continuous presence. Thank you, everyone. I hope this is a motivation for the organizing team, and there would not be any more hesitations to try a new activity and a venture in future, because every new activity doesn't mean we need to be scary. It's errors are part and parcel, but still we tried to avoid at our own levels, and I do not find at any level anything which gone or which went wrong. And I hope participants have the same feeling, and the organizing team also. And rest, I invite all the faculty and the organizing team for a cup of tea in the office, as well as to accompany the organizing team to the vice chancellor to present a memento. Thank you so
Thank you,
much.
Dr. Rajesh. It was really a wonderful program, ma'am, because we have seen the feedback from the students. They really enjoyed a lot the program, especially today's event, this last technical session. They have lots of queries, and it shows that how interest they were taking in the program. And
Definitely, ma'am.
that expert also, he satisfied the queries very, very nicely and effectively. It was really wonderful session, ma'am.
Yes, ma'am. In the beginning, when we initiated with the plan of the moot court
Yeah, we
competition to
all
moot
have
court
that.
training program, we were
Everybody
not
was trying
having
it out.
we were not having such an idea that it can be such a success. But luckily, we are fortunate that it really gone very meaningful.
Yeah, it
And
was
it's
really
all
successful.
contribution of the participants. Even I had taken 2 meetings with the CR separately, even today morning also. And our students are really very much accommodating, that even during the exam time they spared time and became part of this event. Thank you, dear participants.
Congratulations to
Thank
the
you
all
so
committee
much.
members.
This was all for you.
Okay, ma'am.
Okay, ma'am. Ma'am, good afternoon. Good afternoon.
डियर पार्टिसिपेंट्स, फीडबैक फॉर्म चैट बॉक्स में भेज दिया गया है। आप
थैंक यू सर, बहुत जल्दी हम इसको भर के भेज देंगे।